Item number 1.
Made, please, your lordship. My lord, the challenge before your lordship is the Soko's notice that your lordship will find at page 29. Dates are very important, your lordship. 18/5/2023. This notice was issued in respect of my lord financial year 18-19. Whereby, my lord, the input tax credit given under section, my lord, 16(1), 2, and 3, it was denied because of, my lord, filing of return belatedly. Because we have return ought to have been filed, my lord, within September, but it was filed after September. But the return was filed with, my lord, late fee, and it was accepted by authority. So against that reply notice, my lord, we have given detailed reply. Page 31, your lordship. Page 31, where we have given all the, my lord, explanation and why I am entitled for ITC. In fact, my lord, GST has been, my lord, act was legislated for the purpose of a smooth and, my lord, where the input tax credit may be availed by the, my lord, dealer, your lordship. And, my lord, because of only filing in delay, this is procedure 1, your lordship, my input tax credit was denied, and the authority without focus notice was issued by my superintendent, respondent number 3, and order in original was passed, page 39, by additional commissioner, your lordship, whereby he affirmed the demand as given in the so-called notice, your lordship. My challenge before your lordship is on, my lord, when I am entitled under section subsection 1, 2, 3 of section 16 of CGST Act, and only because return was filed belatedly, that is 1 month after, your lordship, in the month of January, my entitlement to input tax credit cannot be denied, number 1. Number 2, your lordship, as per subsection 10 of section 73, my lord, order or so-called notice is required to be issued or made, my lord, within 3 years. And here your lordship will see why I have said, my lord, dates. Notice was issued in the year 2023, and order was passed in the year 2024. So authority lacks jurisdiction on an authority because it is not permissible after 3 years. Your lordship may kindly see subsection 10 of section 73 of the CGST Act.
Can I give it to us a copy? Do you have the volume?
Act.
Yes, it's not.
I have given list of books.
GST.
CGST.
GST.
I will, my lord, pass on, my lord.
GST.
Central. Yes.
Other is also, my lord, so many similar matters is pending before the Honorable Court, as well as, my lord, the same subject matter is also, my lord, pending before the Honorable Supreme Court. But as per the, my lord, so far the, my lord, the Telangana High Court decision, so far the, my lord, the Patna High Court decision, it is, my lord, not in violations of any of the provisions, my lord. The provisions of, my lord, section 16(4) is very specific and objective, my lord. So at this
May I conclude? Then, in fact, my lord, the challenge has been made on 2 counts. First, my lord, we have challenged the constitutional validity of section subsection 4 of section 16. And another, my lord, the order passed is barred by limitation That your lordship will see under section 73, my lord. Subsection 10. So before Supreme Court, only the validity is under challenge. So we have challenged both. Challenge, my lord, because this is a legal issue, your lordship, and our period is 1890, and 3 years expired in the month of September 2022, and order was passed in the year 2024 after approximately, my lord, 2 years. And as your lordship, in the Katina decision like Hindustan Steels and all, when the authority has no authority, then the order passed is, my lord, cannot be said, my lord, with authority of law. So the order is in violation of subsection 10 of section 73, your lordship. And what my learned friend has said, it is yes, my lord. So before Supreme Court against Patna High Court, SLP was preferred, and Honorable Apex Court has issued notice. That order also I am. But since there is a demand, my lord, till your lordship consider it, my lord, no coercive measure, my lord. That much, your lordship. The order passed by Honorable Apex Court.
In your reply, where is the objection?
That I have given your lordship, page.
They could not have recovered on the issue.
No,
notice.
my
Where
lord.
is that? In your reply,
Reply page 31, your lordship.
that they have, the authorities are barred to issue.
My lord, that part, my lord. But this is legal issue, your lordship, I am raising before
Have
you.
you raised that issue before the?
My lord, that is in the, I have gone through, my lord, admittedly. That was in the, my reply, it is. But my lord, this is question of law, my lord. Even if it is not raised, my lord, if it is raised before this honorable court also, your lordship may consider.
So are the statutory provision.
My lord. Subsection 10 of section 73. Chapter 15, section 73, my lord. Subsection 10. May I read, your lordship? The proper officer shall issue the order under subsection 9
Yes.
within 3 years from the date for furnishing annual return for the financial year to which the tax not paid or short paid or input tax credit wrongly availed or utilized relates to, or within 3 years from the date of erroneous refund.
Yeah, let us see the notice.
Notice, your lord.
29.
Page 29. 18/5/2023 it was issued, and order was passed, my lord, on 22/3/2024.
Period.
Period 1819, my lord. It is 1819. Page 30, your lordship will see. As you are aware, the terms of provision so and so, or so and so, written in respect of financial 1819 after so and so.
What is the reply to this?
This is this notice may be issued, my lord. I will file affidavit, my lord.
No, let us, you can file your affidavit.
My lord.
There is no
And
issue.
similar matter is also pending before this honorable court for consideration, my lord. The altogether basically challenge is in respect of section 16(4). And as I've my lord pointed out, this is very specific and objective, my lord. The time limit has to be given, my lord, for filing my lord, claiming tax in full, my lord. That has to be, my lord, done as per the prescribed, my lord, time period. But admittedly, my lord, all the petitioners in other cases also, my lord, they have not done and they have not filed, my lord, that tax in full on time. Because of that reason, my lord, this is very important, specific. So time limit, my lord, the time frame everywhere it is there, man. And admittedly, my lord, the same similar method, even Bombay High Court has passed an order that my lord, goes against us. Against that, my lord, we prepared an appeal before the Honorable Supreme Court. It is pending before, my lord, the Honorable Supreme Court. And against telling, my lord, the Patna High Court order, my lord, that is also pending before the Honorable Supreme Court. Therefore, my lord, in other similar case, which is pending before this Honorable Court, is still, my lord, pending, my lord. My lord will come with affidavit, man.
Just tell us something. How you have received this notice of 18(5) page 29?
It was in portal, your lordship. The GST portal, they upload there. We have to down.
Page 30,
Page
para 4.
para 4. Within 5 receipt of this mail or
When
letter.
did you submit your reply?
It was submitted, my lord, on 15/6/2023.
For how many days? Almost a month.
My
Administrative will consider waiting for the petitions. And Mr. Kato,
For all respondents.
Deputy LCI. For the official responding officer. Petitioners are aggrieved by order dated 22/0/2024. Issued by the Additional Commissioner, CGST and CX Vidhanagara. Funding, GST, Master GST, and NGST. Totaling 4,34,66,380. Avail and utilize during the period from January 2019 to March 2019. Under section 73, linked to number D. CGST Act 2017. There will be corresponding provisions of Arunachal Pradesh State of Goods and Service Tax Act 2017. As well as the corresponding provisions of public service. Whereby currently under section 73, Indian Bracket 9, related section 1, 2, 3, Indian Bracket 2, Indian Bracket small a of this is GST Act 2017. Related to relevant provisions of the bonus of this GST Act 2017, as well as relevant section of GST Act 2017 are being imposed. It is seen that on 18/05/2023, the authority concerned should address the petitions pertaining to irregular availment of input tax credit within the ITC. In respect of financial year 2018, this and availing is 4,34,66,38,27. For section 16, we get 4 of the GST Act 2007. Though I received this dated 18/05/2023. The petitions granted 5 days time to file their reply. The petitioners only on 15/06/2023 submitted their reply before me. Superintendent anti-evasion. Place of the commissioners is the STNCX economy. The interim order 22/03/2024 was passed by the additional commissioner. This is the STNCX economy. After hearing. Income recovery and demand. After the elections. So notice. Panel by 4 weeks. And Mr. Kato have accepted notice in their over the officers. Kato did it previous. No formal notice need to be issued to those respondents. Petitioners also requested extra copies of this writ petition along with the annexes to Mr. Kato within 24 hours. Obtaining necessary acknowledgement from India Tribute. Do you have any other petition number so that it can come?
Malad, right now, I'm not, Malad.
Mr. Goel, do you have
My
any?
lord,
Malad, I'll provide Malad.
synergy that I have. But there, my lord, only 16.4 is under challenge.
No, if the similar matters are pending, it will come together. That's what we want to do.
Malad. 4 to 5 cases are pending before December.
Similar issues. Or you can give us the number.
Malad, I'll provide Malad.
Mr. Katul and Deputy SG submitted for the court that similar matters are also pending for considered adjudication before this court.
My lord, writ petition number 471.
Issue is the same.
Oh, there, my lord, 16 validity of 16.4 is under challenge.
No, the other
471.
matters, so there are also 16.4 is involved.
Malad. Malad. In all Malad the matters, section 16.4 is under challenge.
Yes, Mr. Goel. Number, WPC number.
Writ petition number 471. 2022.
2022.
2022.
2022.
20.
Another connected to such a matter. List along with it. The interim payer of the petitioner shall be considered on the returnable debt after filing of affidavit by the officer respondents.
But till then, no chorus. Otherwise, they will, my lord.
That amounts to, because you have delayedly filed, that's what we discussed.
My lord.
Made you to file your reply. You should have filed it immediately.
But it
That's why
was
not
in
possible.
portal, your lordship. When I have received that, I don't know, your lordship.
Let us see.
Within 1 month.
The interim on the returnable debt.
Item number 2.
Made with your lordship. This is a PIL matter pertaining to some high-handed action on the part of the authorities in proposing to construct a particular road. Now, the issues are twofold here. First of all, the issue is whether the proposal of the road that they are trying to construct, this is particularly relating to a place from Daporiju, Taliha to Tato. These are like very interior places of Arunachal Pradesh. So this is a greenfield project. There is no road there. Now, the proposal is that a road is supposed to come there. So we have now assailed the proposed actions of the authorities on 2 counts.
Yes.
Yes. Number 1 is that the proposal that the authorities have given, that is by the BRO, Border Road Organization, is fetid with illegalities. There has been arbitrariness and there has been non-compliance of the Indian Road Congress, to which their affidavit says that they have followed in toto. They do not say that this is a work that is beyond the Indian Road Congress, which is the guideline for constructions of road. In the BRO's affidavit, they say that we have proceeded for the proposed construction through a particular alignment that they are saying has been approved. Again, there is a question on that aspect also. Now, they say in their affidavit that we are following the Indian Road Congress guidelines. Our first challenge is no. If we go by the Indian Roads guidelines, Indian Road Congress guidelines, and if we see there what are the requirements, it can be clearly proved before this honorable court that the very vital aspect of joint field survey, which is a part of that guidelines, has not been complied by them. Therefore, it's a fatal mistake or a fatal shortcoming on their part, which therefore negates and vitiates their entire action of construction of the road. Now, proposed construction of the road, number 1. And the number 2 ground that we have taken is asking for an alternate survey through a particular route, which we say are far better and far more economically convenient to go through. And to that aspect, there has been various meetings with the concerned authorities. And there was a point of time when, by way of a meeting, it was decided that there will be a joint survey for that particular alternate route also. That also, the authorities who were given that work for survey has not been done. So basically, there are twofold issues here. Number 1, the proposed construction of the road by the alignment through which they are proposing to do is fetid with shortcomings, fatal to the very decision. And number 2 is the second cause or the second ground of asking for an alternate route survey on various grounds, to which they have otherwise in principle agreed that yes, we will go by the alternate survey, we will consider that and we will do that, is yet to be done. So on these 2 bases, we are before your lordships. So another aspect in this matter is, there has been affidavits after affidavits been filed. Now, there are 2 affidavits filed by the agencies who had been actually handed over the work of this survey. Now, to those affidavits, they have come very recently. I'm yet to file my reply on those affidavits. So otherwise, the pleading to the aspect is not complete. And regarding this aspect, if your lordships, because I would otherwise be asking for some time to file my reply against those affidavits filed by the respondent number 8 and respondent number 9. And apart from that, if your lordship would like to see the merits of the case, and I can just place them issues also. But today my position is this, lordship, in this matters. 2 affidavits been filed very recently by the agencies who were entrusted the work of this survey, and I need to file my reply therein. And there has been also, I must say that there is also a stay vacating application been filed by the BRO now. But if your lordship will look into that application, it's very interesting. What the BRO had said in their detailed affidavit in opposition, now they are completely taking a different stand. They cannot better their case by filing documents after documents or affidavits after affidavits. That is MS Gill case, Supreme Court has already said that. They have already filed a detailed affidavit. In their affidavit, they take a ground that we have followed the Indian Road Congress. When I took up this point on the earlier dates of hearing, that if so, where is the joint field survey report? Please provide us with that. They are yet to provide us with that. Another issue that was posed on the last occasion was, they say that the alignment has been approved by the Ministry of Road Transport. That was categorically asked to them to be produced. Till date, they have not been able to produce the actual order of mort approving their alignment, to which they say that they are going to propose that construction of road. These are still not there on record.
Yes, Mr. Katu.
My lord, please, my lord.
If record, I'll elaborate.
My lordship. In my lord main case, PIL, my lord, pleadings are completed, my lord, subject to my lord the affidavit and reply to be filed by the my lord the respondents, my lord. Sorry, petitioner. But my lord, in IA, my lord, today I am for the IA, my lord. So IA is for vacation of the interim order passed by the Honorable Court, wherein that direction has been given for the maintenance of the status quo. My lord, the very purpose of the filings of the IA is, well, there is a communications and there is a the minutes of the meetings held by the ministry at the ministry level, represented by the highest dignitaries, wherein decision has been taken that the project, this is a defense strategic importance road. This has to be executed as early as possible. So therefore,
The petitioners here are one that the road should go through from Taliha to Tatu via Nimpu, right?
correct,
Nimpu through Slim River.
correct,
Now, as per the proposal, it is Taliha Tatu road via Payang.
true, man.
That is the decision of the authorities.
Correct, man.
Now, what is your stand?
Authority decisions of the authorities, as I have already pointed out, this is a strategic defense strategic importance road. This is basically for the purpose of defense, Of course, the other the general publics will use, but the subject matter, therefore, may I take your lordships to the the IA, wherein IA 80,
Yes.
kindly peruse the IA 80, sorry. Page number, 7, Annex 1.
I-80.
My lord. And I have also filed, another additional affidavit also, IA 80, First, I'll take your lordships to page number 7, office memorandum, dated 3rd, 10 March. IA is filed on 14 June,
You know, additional affidavit or in the main petition?
I'm on main IA,
Main IA page 7.
7,
Main IA page 7 is something different. IA 80.
I'm extremely sorry, I'm extremely sorry. Additional affidavit, extremely sorry, Page number 7,
Yes.
This is additional affidavit filed on 40, on the last occasion, the Honorable Court made a specific query for the approval order passed by the authorities. This is the approval authority, the authority by approving the present alignment. Office memorandum 10 March 2022. Subject: minutes of the meetings are held under the chairmanship of Secretary Moore on 3rd March 2022 for finalization of the alignment for consultancy services.
Just a minute.
For professional. Page 7. Additional affidavit. Additional
Yes.
affidavit. Page number 7, I'm reading. First, service consultancy services for preparations of the DFR of 2 lanes of the proposed frontier highway from Nafra to I'm sorry, I'll skip this part. Second one. Please find and close herewith minutes of the meetings held on 3rd March 2022 under the chairmanship of the Secretary Most for finalizations of the alignment pertaining to the DPR for the frontier highways and other railways roads in the state of Arunachal Pradesh for information and necessary manner. This is the the office memorandum furnished to the department executing agency manner. And the specific is given page number 8.
Yes, very good.
Page number 8, my lord, and this is the approval order in the meetings, my lord, held by the ministry.
There are 6.
Yes, my lord. BRO, the project Arunax informs that the BRO is preparing the DPR for Talia Tato stretch under SARDP, NE page A. The alignment report for this stretch has been jointly recommended by CEBRO and the RO MOD as well as by the ADG BRO and forwarded to the ministry MOD by the DGBR in December 2021. He requested for approval of the alignments of this stage in these meetings itself so that the further activities can be initiated for his important stage. Para 2, 7. CBRO, the project Arunans also informs the BRO is preparing the DPRs for, I'm sorry, madam, this is not pertaining to this particular work. Madam, after this approval, this is the approval done by the ministry, madam. This has been duly communicated by office memorandum dated 10th March, madam, 2022, madam. Madam, the approval, everything alignment, madam, has been done. In the highest level, madam. Thereafter, madam, the interim status quo order was passed. Because of that reason, madam, we are not in a position to execute the project, important project work. And approval is also done by the that approval letter that has been also conveyed to the regional officer more by the order dated 22 May 2024, page number 11 of say additional affidavit. And that has been approved by the by executive engineer for regional officer more page number 13 on 3rd May 2022, 24, sorry.
Mr. Katu,
Malad.
we have seen that for this Thalia and Tatu, there is an approval by the MOT and the concerned authority. Now, that approval was for the road Thalia, Tatu via Pine, or it was via Nimpu?
That alignment map has to be produced by them.
Malad, alignment map is at page number 17, Malad.
717.
17 of same additional affidavit.
No signature by any authority on this, just to play the.
Start point is Malad Thalia, Payeng, Then it goes to my lord the short tunnel 60 kilometer ging low and alignment portions my lord and Tato up to Tato my lord.
Now just tell us one thing, once the highest authority grants us approval for construction of a road,
My
particular road, then who decides the options? Because there may be a road, say A to Z, let us say. It may go through BCD or it may also go through MNF. We do not.
Correct.
There has to be an approval, and that uh, alignment, whatever is necessary, will be considered beneficial to the authority concerned. As per the proposal given by these persons who are allowed to prepare the alignment, right? Now, the petitioners hearing are claiming that this road should go through Payan, go through Nimbu instead of Payan. It may so happen that the petitioners are from Nimbu or that particular alignment. So they will be benefited if the road goes through that way. Now, if the road goes through Pine,
Right.
right? So those strategical issues are to be decided by whom?
My lord, as I pointed out, this is a defense strategic importance role.
That's right.
My lord, therefore, my lord, it is up to the defense authorities in highest level. They are the my lord, decision-making body to decide my lord, the strategies, my lord, from where the road has to take. And therefore, my lord, in the meeting, my lord, very my lord, if lordship again, my lord, I'm reading again, my lord, the who was the my lord, the officers present in the meetings while approving the my lord, alignment. Page number my lord, again 8 of my same additional affidavit, my lord.
Para 3.
My lord. And just Peratiri, my lord, everything is there. My lord, the persons who were my lord, present at the relevant point of time is at page number 10, my lord. I'm sorry, my lord, 9, my lord, we start from more authorities. My lord, they are the very much part of the my lord, the decision-making process. Kridar, I mean, Ara Mane, Secretary, SK Nirmal, ADC, John, well, from the more authorities, man. Ministry of Road Transport and Highways. And from Aro Malad Itanagar, 2 representatives were there. And the Ministry of Home Affairs, my lord, directors, PM division, my lord, and the state PWD, Arunachal Pradesh, and so and so, my lord, 2 persons. And BRO, my lord, next page number 10. BR Border Road Organization, altogether 5 representatives were present, and the representatives of the consultants, my lord, 6 in numbers, 7 in numbers, I'm sorry. Representative 7 in numbers, my lord, they were present, my lord. And after the my lord, decision has been taken and the approval has been granted, my lord. And my lord, why did in the case that this is a civil my lord, project work, my lord, normally that will be my lord, with the consultation of the other party, my lord. But this is a matter the strategic defense strategic importance, my lord. Therefore, my lord, this is the group of the officers in the highest levels who decides the my lord, my lord, alignment.
Instead of building quality source, it's moving policy. Security of the country. Yes, Sarma.
Yes,
Tell us one thing. When a matter relates to the security of the nation, anything. any
It does
road,
not.
any
It does
building,
not. That is my first
See,
objection to that. Only.
listen.
I'll just show it also.
Then why the BRO should be involved?
BRO.
If it is not the security of the nation, then why
Yeah.
BRO is involved? It should
Yeah.
be PWD or the National Highway.
No, I'm just.
Don't make answers absurdly.
No.
BRO prepares the road where?
BRO makes roads around the border areas.
Why? Why?
Because
Border means what?
that is true. That is
And-
true. But this is not. This is not
When
a.
the matter relates to the security of the nation, when the matter relates to transportation of arms and ammunition to the border areas, defending the nation, the border road organization comes in and prepares the road, right?
Yes.
Then tell us, when the security of the nation is involved and a decision is taken for construction of a road, who will be the authority? The public or the authorities concerned to decide which will be the strategical issues, which will be strategical points? Can the court intervene in such areas?
If there are.
It's not a public road.
I understand. It is otherwise a national highway as has been notified in the Indian Gazette provided by the BRO's affidavit themselves.
It may be a national highway.
So national highway will be used by the army, but by the
Definitely.
public also.
Definitely.
So if it is meant for the public also, war times will come sometimes, but the road to be used by the public will be there every day. Public will be using the road every day, Lordship. So if it is a national highway, as per the official gazette annexed by them, then it is a road that is meant for the
Is
public,
it
for
made
public
for the
interest.
public or it is made for the purpose of defense?
For public also. Because
So us.
because why I am saying so,
So us.
this aspect of national importance has been brought by them only in their IA. They have filed a detailed affidavit. In their affidavit, not a single semblance of this army aspect is been brought in. And can they produce one recommendation by the army in the before the honorable court?
Who will decide?
No, if
That
they
is
can,
the reason. That is
if
the
there are
reason.
also if there are palpable illegality in the decision making process, this honorable court has plenary powers to look into it. I'm not asking your lordship to enter into the nitty-gritties of that alignment, but only on the basic substantial aspects of followance of the rules. If it has not been done, that is the end of the matter. This honorable court can always look into it.
Please come to page number 7 of the additional affidavit.
Yes, lordship. I'm on that, lordship.
Read the second paragraph slowly. You will realize on that.
Please find enclosed herewith the minutes of the meeting. What was reading that? Minutes of the meeting held on 3/2022 under the chairmanship of Secretary Mort for finalization. What I'm showing that this is not the finalized order. For finalization of alignment pertaining to the DPR for Frontier Highway and other roads.
Frontier highways.
Then I'll just produce that affidavit. If a lordship will come to their affidavit, BRO's affidavit, BRO's affidavit in the main case, lordship, the detailed affidavit that they have filed, and therein, if a lordship will come to page 43, the Gazette of India.
Which page?
Page 43 of the BRO's affidavit in the main case. Respondent number 6, 7, 10, and 11's affidavit, which includes the Ministry of Mort as well as the BRO. At page 43, if a lordship will kindly come.
Respondent number 6 and 7.
Yes, Lord. This is an affidavit filed by 6, 7, 10, and 11, Lordship.
It was filed on 7th of February.
Yes, Lordship. I do not have the date in my affidavit.
Okay.
Yes.
Shown by whom? I Murthy.
By the BRO.
By Murthy. Murthy H. Now, this is their detailed affidavit. There is not a single whisper of army or defense. If a lordship will come to page 43. Page 43, the Gazette of India. You got that? In fact, in this route, 2008, they had tried to make a road. From 8 to 2020, they were trying to make a road there. They have failed. Public money has been wasted. They themselves say in paragraph 4. Indian Affidavit paragraph 4, they themselves say. From 2008 to 20, they were trying to make a road in that side. They failed. Public money was wasted. There is a FIR also been filed. There is some police case also going on for wastage of public money and corruption therein. That is also there in our PL. Paragraph 4, they themselves say. Now again in that side, they are trying to make a new road now, which therefore we say is not possible. It's a treacherous valley. You cannot go by that route. And therefore we were asking for an alternate survey. We're not saying don't go by that route. We're saying also please consider the other route, which they say they will do, but they have not done. And what they have done is also vitiated by illegalities because they have not followed the Indian Road Congress, to which they are saying that they have followed in their affidavit. Paragraph 6. They have said they are following the Indian Road Congress. And I'll show that they have not followed the Indian Road Congress. And page 43 is that Gazette. Page 45, lordship will see, it's a national highway. Page 45. Top portion. In exercise of powers under section 5 of the National Highway Act. The chart lordship will see. New National Highway 913, Huri, Tali, Taliha, Tatu. And this is published in the Gazette. How can they simply make a national highway into a frontier highway by just simply inscribing the word somewhere in some document, some meeting paper? They have to amend the Gazette first of all. And this is not my paper, this is their papers.
Mr. Sharma, please take your seat.
Please, Ross.
We'll get back to you. Mr. Sharma. The affidavit of the respondent number 6 and 7.
Yes, Lordship.
You are not going on the statements. Please come to please appendix B.
Appendix B.
It is at page 17, 18 you can come. 18 is a type copy.
Lordship. 8. 17, 18.
Please read. In reference to, it was from the Deputy Commissioner.
Yes. This is from the Deputy Commissioner.
Yes, can you read?
Yes, Lordship. In reference to the above subject, you are requested to clearly, I think state is not this, that the ground survey and public consultation has been carried out in consultation with LM officials, and whether the said road stress is a part of the national highway. If it is so, you are requested to obtain clarification from the MOT as to whether NH Act 1956 is proposed or not for frontier highway, and if they have any observation regarding use of NH Act 1956 for land acquisition of frontier highway. Further, as information sought from Ceiling Valley Public People Welfare Forum of Taliha Payang Circles, you are requested to furnish the following informations to the undersigned for clearly in the process of land acquisition in the above stress. Number 1, a copy of the physical field verification survey report, a copy of joint physical survey report. Now, my case is these reports are not there.
Come to page 20.
20, yes, Lordship. Yes, this is a reply. Now, if your Lordship kindly sees, they say that the road stress Taliha to Tato is a part of the frontier highway as per Gazette notification 20 March 2023. Now, if your Lordship will see the Gazette notification of 20 March 2023 and come to page 45, it is clear it is a national highway. This is a wrong interpretation or a misrepresentation of the facts.
Read page 45.
Yes, Lordship. Page 45. In exercise of the powers conferred under Section 5 of the National Highway Act, the central government hereby directs the Border Roads Organization under the Border Roads Development Board shall exercise the functions relating to the development and maintenance of the stretch as specified in column 3 of the table of the corresponding section as specified in the corresponding entry of column 2 of the national highways as specified in the corresponding entry 1 of the table. And now Lordship will see the table. New national highway number, new NH 913, Huri Tali, Taliha Tato, Ville Miging in the state of Arunachal Pradesh. So if a lordship will now therefore compare both the documents or both the pages, here they say the road stress Taliha Tato is a part of the frontier highway. And they have referred to this notification published in the official gazette. Now in the official gazette, if a lordship will see, there is nothing referred as a frontier highway. They simply say it's a national highway. I will go by the document as is there on record. The document otherwise does not speak that it is especially a frontier highway is designated for that particular road. It is a national highway under the National Highway Act. So therefore, it will be otherwise meant for the public and transportation of public's goods and everything for commercial and socio-economic development. Yes, during road times, during war times, definitely it will be used by army. All roads are used by the army.
Come to page 46.
Yes, Lordship.
Written
Lord.
notification.
That notification. Page 46. In exercise of the powers under Section 5 of the National Highway Act 1956, the central government hereby directs the functions in relation to execution of the work pertaining to each of the national highway described in column 2 of the table hereto, annexed shall be exercisable by the state government specified in column 3 of the table against each highway subject to condition the state government concerned shall in exercise of such functions be bound to comply with the rules for the time being in force under the State Act, and for the purpose make the following further amendments to the notification of the Government of India, erstwhile Ministry of Shipping, a number dated such and such. In the said notification in the Schedule 2 for serial number 2, the entries related hereto are following to be substituted, namely, they've
Then
given.
come to page number 47.
Yes, Lordship.
The last 4 lines.
Last 4 lines, yes. New NH number 713 and new NH 913, excluding Huri, Tali, Tato, that entire name is given, as are situated in the state of Arunachal Pradesh. So for this road, the state government, yes, Lordship. For
That
this,
part has been excluding the
for the state government's function, because this is a part of the notification 1311 notification. Here they are saying that these roads will be otherwise maintained by the state government. Then they carve out an exception to that by saying that this national highway will be maintained by the BRO, because as is given in the first notification, that this road will be maintained by the BRO and not by the state government. There is no dispute that this road will be managed by the BRO. There are various roads in the frontier areas, in the border areas, which are maintained by the BRO. So there will be certain roads, I think, in our Bodoland areas also, which are maintained by the BRO. So these roads are there, but this is not particularly a frontier highway, or for that matter, specifically a army used road. This is my humble submission before Lordship. This is a road meant for the public at large, and yes, for the army also. But my further case is, even that road, if the authority have said that they will comply with the Indian Road Congress guidelines, as they have said in paragraph 4 and 6, they have to do that. And I will show that they have not done that. Lordship will allow me to place those facts, and everything will be clear. Just in the name of defense, anything and everything cannot be allowed to be done. That is my case, Lordship. And there is no letter on record saying that the army has recommended this road to be specifically built and utilized by them. It is not there. Only in their IA, they have developed this new aspect of this army or defense requirement. In their original affidavit, Lordship has seen there is not a single whisper about the requirement of this road by the army. This is something that they have developed later in their IA. So therefore, both documents has to go for a conjoint reading. And also this field verification report, which the Deputy Commissioner was asking for, is nowhere on record till date.
See, if it is under the state of Arunachal Pradesh
Yes, Lordship.
process, the national highway, then probably they are supposed to give the reply.
Give the
If
Lordship.
it is under the BRO,
Yes, Lordship.
then they may not require. Because the assessments are different. Now, one more thing I have seen.
So the affidavit says categorically that they are following the guidelines as is provided. I have annexed that guideline in my affidavit. Lordship will kindly have a look to that guideline. I'll just place the facts properly, Lordship, for my satisfaction.
Just a minute.
Yes, Lordship.
Please come to page number. 50.
Of the said affidavit?
Sure.
Yes, Lordship.
Can you read?
Minutes of meeting held under the chairmanship of R.O. Itanagar on 10/4/2023 for review of progress of consultancy service for preparation of DPR for two laning of the proposed frontier highway from Nafra to Vijaynagar in the state of Arunachal Pradesh. The R.O. Mort welcomed NHIDCL and his team officers of BRO and representatives of consultants. It was informed to all that the meeting pertaining to the NH work in Arunachal Pradesh under the chairmanship and secretary was held on 6/4/2023, and the ministry has targeted sanction and award for construction projects for the entire frontier highway NH 913 section under the current year 23-24. It was apprised that the entire NH 913 has been entrusted to agencies via Gazette Notification 23/23. As per notification, stresses entrusted to various agencies are, and the Lordship will see as serial number 2 to the BRO. There is no dispute to that. Direction of the ministry dated 3/4/2023 regarding handing over of the DPR of the respective stresses to the concerned agency was also intimated. As discussed, contracts for all ongoing DPRs in the section entrusted to BRO was already signed by them and handed over is not required. However, DPR has been prepared by the ministry directly in the sections and entrusted by the state PWD and NHIDCL. It was decided during the meeting that all such DPRs shall be handed over to NHIDCL and the state PWD through signing of tripartite supplementary agreement 28/4/2023. It was also apprised to all that the cost optimization committee formed for suggesting measures to reduce the construction cost of the national highway, frontier highway stresses as circulated is recommended. Its recommendation. Same has already been forwarded to all the consultants to incorporate the measures in feasibility stage. Consultants issued for submissions of feasibility report at the earliest after duly incorporating the measures suggested by the committee. The MORT informed officers of the BRO that ministry is set a target of sanction as well as award of 425-kilometer length of project falling under the NH 913 frontier highway stress. As BRO has repeatedly intimated that DPR are in the final stage and ready for sanction, the ministry has asked the BRO to submit the DPR by the month of May for sanction, considering the targets for award status, individual DPR. We'll skip one and I think we'll go for the
Roman 2.
Roman, yes, 2. Taliha Tato, the detailed status of contractual deliverables and pre-construction activities by MS Eptisa were delivered. So I'm just pausing here. FTSA is an agency is a private agency which was engaged for survey and for proposing of the alignment. This is not a construction or a DPR making, it's for that purpose only. The consultant assured to submit the revised DPR after incorporating the recommendation of cost utilization committee within 20th April. It was noted that no work related to land acquisition forest clearance has been done till date. Consultant assured that LA work including joint inspections shall be completed as fast as possible and cost estimation to be submitted by 15th May. Submission and upload of proposal for forest clearance was also issued by the consultant to be completed by 15th May. Representatives from MS Ignicio were not present in the discussion. This is also a firm because there were two stresses. The road was from 0 to 30 and from 31 to 109. These are two stresses. For 0 to 30, it was this Ignicio, and we are concerned with this particular stress. Was not present during the discussion. Representatives from MS Bloom did not attend the meeting. A BRO was requested to take note of this. RO NHIDCL pointed out that strengthening of the bridge located at the Taliha end would be very much required for enabling construction activities in the adjoining stretch. SE Project Arunak was requested to take necessary measures. SE Project Arunak was also requested to conduct regular review and ensure timely submission of all reports as per contractual obligations. So that target set by the Ministry for sanction as well as award in 2023-24 can be achieved. RO Mort informed NHIDCL that Ministry has set a target of sanction as well as award of 478 length of project falling under NH highway stress. The DPR in this regard are to be submitted by the month of July for sanction. It was decided that tripartite supplementary agreement would be signed on 28/4/2023 and NHIDCL will completely take over the work for sanction and award as per target fixed. Accordingly, individual DPRs were reviewed jointly by RO Mort and RO NHIDCL as under herein. Taliha Tato. Taliha Tato, I think it is not there. So as per my instructions, DPR work has not been done for this stretch. That is why it doesn't figure in this minute also.
Page 51.
No, 51 I have read. This is again 52 after that for DPR sanctions.
This is sufficient indication that this is a frontier road, right? So if it is a frontier road, what do you have to say?
Even if it is a frontier road, to which I respectfully and humbly would like to deny to that, because the notification in Gazette is not been amended. So probably using the word loosely, I'm subject to correction, Lordship, using the word loosely in certain minutes, in certain administrative letters, probably cannot water down what is the intent of the legislature as has been provided in the notification, saying that this is a national highway, because it is in the official Gazette for the public to know that this is a national highway NH 913. Now, where we see this frontier highway definition or the word is being used is only in certain correspondences made between the authorities, wherein they are using this word frontier highway. So my humble respectful submission would be, it cannot water down the Gazette which clearly notifies this to be a national highway. But be that as it may, that is one aspect of the matter. Even if it is a frontier highway, the authorities will not have unfettered rights to do anything and everything, and it will be beyond the scrutiny of this honorable court. My humble submission is that they may be the highest authority, but not as high as your lordships are. Your lordships has the right to at least look into the allegations that has been raised by a particular litigant before honorable court and maybe look into it and see whether these are grave or not, at least to that aspect. If clearly a case of illegality is made out, obviously this court will have plenary powers to interfere with that. That will be my submission insofar as if it is even held to be a frontier highway. Merely using the word defense, unfortunately, I may say, using the word defense will not give them impunity over each and every act of theirs. It is also subjected to scrutiny of this honorable court, and this court has ample jurisdiction, full jurisdiction to look into that aspect, at least to test the allegations raised by a litigant. And those, if your lordship will permit me, I'll just show. In 10-15 minutes, I can just show our allegations and whether it has been met by the authorities from the records itself.
What do you mean by EPC mode?
That is engineering, procurement, that turnkey project.
And SARDP?
SARDP is a central government scheme for accelerated road construction. This has been a scheme that is applicable in all the Northeast states. And under SARDP, also civil roads are also made. I did a matter in Nagaland, so I know about this SARDP. Under that scheme, these roads are made. National highways, two-lane roads, everything are made also. That fund comes from the center.
SIA means
Also,
SIA. Any idea, Mr. Kato?
Well, I'm sorry,
Page number 62.
this is for land acquisition notice.
That is why we are
Yes. Also, in our affidavit, we have stated that all the concerned people of that area, they have given affidavits that they will not ask for compensation also in that route. Economically also that will be viable. There is no compensation being asked. The roads are lifeline and there is no road in that side. They are expecting for a road. So they are saying no compensation. They don't want compensation. Even a road is made to that route. I have annexed those documents also. Social impact assessment, SIA. Under the Environment Act, again, there are some requirements. So one of the requirements is social impact assessment. That is not required. That side is an uninhabited area. Therefore,
Yes, Mr. Katu,
My lord.
what do you mean by frontier road and national highway?
My lord,
What do you mean by frontier road and national highway?
my lord, categorically, we have not given, admittedly, my lord, in our affidavit, my lord. But my lord, the subsequently, my lord, from the, my lord, the various correspondence and the approved done by the my lord ministry, it is, my lord, the national frontier highway, which is basically for, my lord, the defense purpose, my lord. The, my lord, it is, of the fact that, my lord, the road is going to be constructed from Bomdila to, my lord, the touching, my lord, all the bordering area, my lord. Admittedly, my lord, there is a dispute, to be financed by the World Bank, my lord, wherein, my lord, neighboring countries are interfering. So that is under process for, my lord, the constructions of the road touching the border areas, my lord. Basically for the purpose of the, my lord, defense, man. And regarding, my lord, another aspects, my lord, wherein, my lord, for the public utility, my lord, that has been excluded from the, this present one. For that moment, my lord, may I take your lordships to the affidavit? My lord, IA, in my IA, my lord, again, my lord, IA number 80, page number, my lord, 18 of my IA, my lord.
Additional affidavit or main?
Oh, main IA, my lord. Page number 18. This is relevant as because, my lord, the other part has been foreclosed. Para 4, page number 18, my lord, I'm reading. Further, the secretary, RTH so and so mentions that based on recommendation of the DGMO and the BRO, my lord, page
Page
18, para 4, my lord. The DPR work of the CM Mechuka was dropped and contract was foreclosed. The finalizing the DPR for the CM Mechuka is desired by the Honorable Ministers of the Art and Sciences and would further take minimum 18 to 24 months. However, as discussed during the high-level meetings held on 8/12/2023, wherein the MOD they informed that they will consider take up the CU Mechuka directly through GS funding. MOD may take necessary actions in this regard. By this particular paragraph, but the ministry is communicating that for other purpose, directly it will be constructed from the Sium to Mechuka, and which will be not including inclusion of this.
we're not concerned with CM Mishika.
And the funding will be also from,
In fact, you should have read 5.1. 5.1 says Talihat-Tato direct alignment shall be a part of the frontier highway. But then what my argument is, it's only been loosely used in various communications and minutes of meetings. But they themselves has produced the official gazette whereby it has been notified to be a national highway. Where is the amendment to that notification? That is pertinent. Simply using a word loosely in communications and in minute recordings probably cannot change the nature of the word, nature of a particular stretch, which is otherwise been recognized by a notification in an official gazette. There has to be some specific order, notification, and probably also amending the earlier notification.
Mr. Kato. Page number 18 of your affidavit.
my lord.
Para 3.2 and 3.3. Kindly read and explain.
My lord. I'll
See, if you need to take the help of the BRO officials, you can take.
my lord. He is officer
If
directly.
they are present, you can take so that they can explain. If you need, otherwise we are not calling them. If you need, then only.
My lord, admittedly, my lord, this will be better explained by the.
This is not an adversary litigation, so definitely I think
Since, if you need, then only, otherwise,
Right.
you just read and explain.
My lord, my brother, it will be better explained by the.
May I, my lord,
Yes.
the,
What is the designation by the?
I'm Brigadier Yogesh Nair. I'm the Chief Engineer Arunang.
You might be hearing what Mr. Sharma is arguing, that this national highway part.
Right.
Is not a frontier road.
My lord, it is a frontier road only for the purpose of whenever MORTH, Ministry of Surface Transport, has to fund, it has to classify the road as national highway. That's why this has been classified as national highway. And then what they have done is they have given those stretches of road which are of strategic importance to border roads, like from Huri to Talia, Talia to Tato, and ahead of that there is a stretch till ahead of there were one more stretch. All this stretch has been given because these are strategic roads. And the reference in which what the discussion was, when the honorable minister had gone and discussed this matter, that he doesn't want the road to be going from the alignment Tato to Talia to Tato, and he requested that this road should go from Siomi to Minchuka. In that time, Director General Military Operations has said that this is the alignment what the formation army wants on ground. So this alignment should not be changed. We should go ahead with this alignment, and if you want, then we will have one more roads which will be cleared. And that's what has been said in this communication, sir, that we will clear under GS funding this road. And it makes it very clear that this stretch of road from Telia to Tato is a strategic road. And whenever a DPR is made, the DPR has been approved. So the first thing that IRC has not been followed, the MORTH will not clear any DPR if IRC specification is not followed. So it has been followed to the hilt. One. Secondly, whenever a strategic road is taken, 2-3 strategic alignments are discussed. These are approved with the army authorities, that is 3 Corps, and it goes to DGMO and they cleared it. After they have cleared, then only the alignments is recommended and approved by the ministry, sir. So all this process has been followed.
You have heard what Mr. Sharma is saying, that in the notification regarding the construction of the highway, there is no such amendment that part is the frontier road or for the defense purpose. There is no such mention, or it has not been subsequently amended, showing it that it is required for the defense purpose.
My lord, as I have said,
this is a frontier highway, and this project has first been thought of by the armed forces through GS funding. But since the money was an issue, this was moved to secondly to MEA, whether they would MHA, or then thereafter MORTH took on this word. However, MORTH cannot fund any amount, any project unless it is notified as national highway. That's why they have notified this as national highway. But, however, this project is frontier highway.
Let them produce the records to indicate this decision-making process.
Okay, thank you.
So may I just submit? One.
We'll come back to you.
Yes, only one thing that was coming from him. Mr. Brigadier has said that they have followed the Indian Road Congress to the hilt. In fact, that is a statement in their affidavit also. Now, Indian Road Congress, that guideline I have annexed, it says field verification, joint field verification, because what our allegation is that these people, this Epista and Ignicio, those engineering firms, they had never even done physical verification of those areas. This is our allegation. So therefore, our specific allegation is that this has not been done. Therefore, you could not have approved this alignment. So what they come up with their affidavit, they are saying, yes, we have followed the Indian Road Congress. In fact, Mr. Brigadier also said we have followed the Road Congress. Now, one of the vital characteristics or requirement under the Indian Road Congress is a field verification report. In their letter at page 20 that we were referring to at page 20, where Deputy Commissioner's letter was replied by the commander, he also says, find the field verification report at Annexure A. If we see the Annexure A here, there is no field verification report. Till date, before this honorable court, they have failed to produce the physical field verification report showing the entire kilometer stretch by kilometer, what are the bridges, that survey report, it is not there. So this is therefore what he has said is purely sustaining what my case is. It therefore vindicates what I am saying. If he says the Road Congress has been followed, let him produce the physical land verification report. Then I can agree that yes, a proper manner has been or procedure has been followed while this alignment was decided by them. Yes, please.
Mr. Kato, kindly read para 3.2 and 3.3 after page 18.
Well,
Slowly.
it was mentioned there, the frontier highway is
3.2.
2, man. The representative of
Or you can read 3.1 also. No issue.
Mallet. As
It was
mentioned there, the frontier highway, page number 18 of my additional, is mainly being developed for defense requirement, and therefore the DGMO may clarify its positions on suitability of Talia-Tato direct alignment or through Siu-Mechuka alignment without considering
progress of DPR.
progress of DPR. 2. The representative of the DGMO, states that the alignment through Siu-Mechuka is very close to the international border, which make it strategically disadvantageous. This road cannot be used at a time of war for defense-related logistics movement. He insisted that this decision has nothing to do with the DPR progress. While the road may serve to the civil population, it would not be beneficial for the defense at the time of war. He further states that the Talia-Tato direct alignment is a priority stretch besides 2 more sections, that is Bile Mingi and the only the highway, and this is in other location for defense requirement. 3. The secretary so opined that the frontier highway is aimed at becoming backbone of the defense logistics movements to counter China in Arunachal Pradesh. If an alignment is disadvantageous to the defense, it may not be made the part of frontier highway. This must have also been considered by the then secretary and so on dated 13/10/2022 in discussions with the then DGMO, and accordingly frontier highway was declared as national highway adopting the Talia-Tato direct alignment. By this manner, it is clear.
Continue.
Manner. 4. Further, the secretary so and so mentions that based on the recommendations of the DZMO and the BRO, the DPR's work of the CU Mechuka was dropped and contract was foreclosed. The finalizing the DPR for the CU Mechuka is desired by the Honorable Ministers of the Arts Sciences, who would further take minimum 18 to 24 months. However, as discussed during the high-level meetings on 8/12/2023, wherein the MOD informs that they will consider taking up CU Mechuka directly through GS funding. MOD may take necessary action in this regard. After deliberations, the following decisions were taken. 5.1. The Talia Tato direct alignment shall be part of frontier, the highway. BRO shall expedite the DPRs and the free constructions works and get the civil work, the sanctions at earliest. 2. The MOD, MHA may also examine the feasibility of the CU Mechuka road for development through their funding and other sources of fundings. Well, basically, two decisions were taken. One is this is frontier highways. It has been now clear. Of course, Malad, admittedly in the Gazette notification that has not been amended, Malad.
It has been declared as national.
And then regarding the other part, but the feasibility, Malad, basically it is not the subject matter of the dispute. But we are on 5.1.
Come to page number 17.
Yes, Malad. It is the minutes of the meeting, Malad, held on 3rd January 2024. At so and so, under the chairmanship of the secretary, so and so transport Bhavan and so and so. The list of the participant is added. A meeting was chaired by the secretary so and so on dated 3rd January 2024 at so and so to review the alignments of the Talia Tato sections of the Frontier Highway, National Highway 913. The meeting was attended by the officials of the mall and which DZ, RT, so and so, so many officers, I'll skip this part. The record discussed made during the meetings are briefed as under. 1. At the outset, the secretary the welcomes of the participant and asks the chief engineers so and so to start the proceeding. The CEC made a presentations and they apprised the honorable ministers art and science. The head called an informal meetings at his official residence on 13 October 2023 for reviewing the works of the frontier highway in the state of Arunachal Pradesh. The meetings was attended by the so and so, and during the meetings, the honorable ministers inter alia inquire about the developments of the states of Talia to Tato, Baya, Sium, Mechuka, and express his surprise and displeasure on knowing that the development is being envisaged directly from Talia to Tato instead of Baya, Sium, Mechuka. The honorable ministers inquires that how the direct alignment that has been taken while ECB has given the 26 obligatory points of the frontier highway, which includes the route through Talia, Chium, Mechuka, Tato. 2. The chief engineer so and so further apprised that the meetings was again the call by the honorable ministers of the art science on 8/12/2023. The said meetings was co-chaired by the Sri so and so Tapugao and the Sri so and so chief minister. And the meeting was attended by the so and so. I'll skip this part.
In this meeting also. Same 1.2, it starts in this meeting also the alignment
Yes, ma'am.
after Arunachal Pradesh.
In this meeting also, this one.
Well, in these meetings also, the issue of the alignments of the Talia Tato sections of the frontier highway was reiterated by the honorable ministers art science. The DG and SS mentions that The developments of the direct route through Talia to Tato is in accordance with the requirement of defense, as decided in the meetings of 13 October 2022, chaired by by the then Secretary so and so, which was on the CU Mechuka section. They could be taken up separately through GS funding, and the present developments work along the Talia to Tato following direct route may be allowed for the development as envisaged. However, the Honorable Minister so and so insisted to adhere with the route finalized and given by issue B I. The Secretary so and so inquired as to why the Talia Tato direct alignment was considered instead of the Talia Tato via CU Mechuka in the first place. If the same way, the also obligatory funds, the chief engineer NESD informs that during a meetings they held under the then secretary on 13 October 2022, the BRO insisted that the out of the two roads, the construction should be either one may only be taken up to serve the purpose as CU from Talia and Meshuka from Tato are already getting the connected from roads under MOD funding. The BRO informs that the DPR for Talia Tato direct alignment is in advanced stage under SARDP Phase A and may be considered for sanction. This was supported by the DGMO, and accordingly ongoing DPR for the CU Mechuka was foreclosed. 3. The Secretary so and so mentions that it is not understood why work has not yet been sanctioned, despite of BRO informing in the said meetings of October 2022 about the advanced stage of the DPR. Therefore, this cannot be accepted as reasons for opting an alignment over another.
So now 1.2 is 17.
Malad.
Which route was finalized
Malad, as per this
and given by the ECBI?
route finalized is Talia
Which route?
Tato, my love.
Which route was finalized? Because given by the ECBI, which
None.
route was given by the ECBI?
Malad, it is Talia Tato direct alignment.
Through which?
Malad, maybe is also annexed.
That's what I want to know.
My additional alignment. It is Payeng start point is
That is the present map is coming. The earlier one.
Which was approved by the ECPI, because 1.2, the last line,
Malad.
whether it is the road that goes through Payeng or it goes through Nimpu.
Malad, as per the map annexed additional affidavit it is additional affidavit of IA page number 17, Malad. Approve. I think at present approval of page number Malad 17 of my additional affidavit.
What is ECBI?
CBI, ECBI.
1.2. 1.2 last. Page 17.
Yeah.
Page 17 of IA.
Well,
Which page? Last line, 1.2.
just for the FOIU. It's very difficult to understand every time they are mentioning the abbreviation.
Sir, ECBI is another company, sir. Actually, they have approved earlier from Tato.
Okay, okay, it is somewhere there in one page, I just saw.
एक कोई private firm, sir.
That meeting.
हमारा firm नहीं, sir. From our side also.
Okay.
Now, madam, after the DPR is prepared, the next step is for several other procedures. Like the environmental clearance, notifications, thereafter the final notifications for acquisition of the land, claims and objection, and many other things is still pending because of the pendency of this PIL. That is the whole barrier in the IAM. I'm sorry, madam, the easy way had not also been explained by the officer concerned.
Doesn't matter, doesn't. Mr. Sharma,
Yes, sir.
your interface is on page 85 of the repetition.
85 of the repetition. Yes, Lord, sir.
That's your facts of the case.
In fact, at page 41 is where the first representation is. Page 41. This is the representation given on 16/11/2022, wherein we had categorically given a differentiation of both the alignments and how advantageous the other would be in a form of a chart. So this is one aspect of the matter.
Right.
Because I have got two aspects. One is the seeking of the alternate route, number one. And the other aspect is the proposed route to which they are proposing is not in compliance with the requirement of the law as has been professed by them to have followed to the hilt. These are the two aspects.
Why it is not compliance with law?
Yes, Lordship. If your Lordship will see their affidavit in paragraph number 6, the BRO's main affidavit, the original affidavit. If your Lordship will come to paragraph number 6, it says, the answering deponent,
Please carry on, carry on.
yes, the answering deponent states that as per physical survey, the proposed gradient alignment are as per the Indian Road Congress guidelines. This is one. And then again at paragraph number 19, they say, the answering deponent states that the physical field verification conducted by both the implementing agencies.
So you are saying para 6 and para?
Para 6, then para 19, and lastly, para 24.
Okay.
Para 24 says the answering deponent states that all the environmental factors have also been considered while finalizing the approved alignment, and all IRC guidelines have also been followed. Indian Road Congress guidelines have been followed. So this is their stand. Their stand is that Indian Road Congress guidelines is followed. And number two is that the physical field verification has been conducted. So these are the 2 points. Now this physical field verification is a part of the Indian Road Congress that you also will find in the affidavit in reply to this that we had filed, wherein we had annexed this. But this is not a matter of dispute because they have themselves agreed that this is required. Just for abundant caution, if I may just place that the Indian Road Congress in our reply filed on 29/4/2024. Page 15 is the guidelines, the Indian Road Congress.
Yes.
And therein, if you'll also will come to clause 5. Clause 5.2, what's the page number? Page 26.
Yes.
Page 25, also will see survey and alignment of hill roads. Page 25.
Page 26 here.
Page 25, where it starts, this particular paragraph starts.
Page 25 starts with
I'm
planning.
sorry,
package.
I'm sorry, Lordship. My pagination is page 26, yes, Lordship. Survey and alignment of hill roads, and therein at page 27, 5.2, survey method, sequence of fixing of alignment. Therein, Lordship will see 5.2.1, clause C, preliminary survey of routes, E, ground verification and preliminary survey of alternate alignments, F, final detailed location survey. This is the requirement under Indian Road Congress. Now they are saying that they have done this. In their paragraph 19, they have said that we have done the field verification. My entire case is, had they been able to produce the field verification reports with the Honorable Court, they have not. In fact, if a lordship will now come to page 18 of the affidavit itself, page 18 of their BRO's affidavit, wherein the Deputy Commissioner of the BRO's affidavit also. I have shown your lordship the requirement under the IRC. I have shown your lordship that they are saying that they have heeded by the IRC's requirements. They have also made a categorical statement in their petition, in their affidavit that they have followed.
Page.
Page 18.
Okay.
Yes. So page 18, if your lordship will now test these averments of theirs. The Deputy Commissioner writes to the Commander, lordship had seen this document, wherein the Deputy Commissioner also asks for these physical field verification. Now, a reply to this is there at page 20. Page 20, the concerned BRO official writes back to the Deputy Commissioner
Yes.
saying, number 2, lordship, that lordship has seen that point, where he says that this is a frontier highway, but he refers to the notification which is a national highway. Number 2, 3. Also, following informations appended as desired in the above referred letter. Number A, copy of physical field verification conducted by both the implementing agencies, along with copy of the various alignments explored by the DPR consultant, are enclosed as Appendix A. Now, if your lordship will see the Appendix A, in fact, this affidavit holds no Appendix A, and the documents that they have annexed here is nowhere lordship will find the physical field verification. In fact, in earlier proceedings also, I have raised this categorical objection, saying, please produce the physical field report to indicate that the mode or the process of examining or survey of the road has been done in due process of law, as you have professed. But till date, they have not been, and this is very important. Why I say it is important? Because if you don't have a survey of where you are going to construct, what are you going to construct? How are you preparing your DPR? And this has some meaning. Why I am saying this? In paragraph 4, if a lordship will see of their affidavit itself, what they have stated. They have stated that they had attempted to make a road in that particular area through Payang from 2008 till 2020, and it has been foreclosed. What took them 12 years of attempt, and finally there was a failure, to which there was also a police case going on that your lordship will find in our petition at page 180. There is a FIR of corruption, page 179 of our writ petition. For that particular episode, 2008 to 2020, public has taken this ground saying that for 12 years you have plundered public money trying to make a road in an area where it is not possible. The money was plundered. It is ultimately public money at stake. If you could not have made a road in that area, today, without even a survey report being placed before this honorable court, which is required, to which they profess that there is a requirement of a physical field report, it's not before this honorable court. So therefore, it is a complete farce. This alignment, this company, Ignicio, it was not coming before this honorable court even after multiple service of notice. Finally, it has now filed an affidavit wherein they have stated something which is again even totally contrary to what the BRO is saying. They say approval came in 2023, and the BRO is saying that approval came in 2022. There is certain fishy activities going on behind this. In the name of defense, these things cannot be just simply brushed aside. Yes, I understand. It may be for defense. I am not disputing it to the hilt. Maybe, yes. Every road is meant for defense. But then, at the name of defense, can they override? Can they have impunity over the requirement of law to which they themselves are proposing? They themselves are professing that yes, we have followed IRC. Yes, we have done field valuation report. Field valuation is there. Why could not they produce it till date? And Ignicio, the firm which was, that's a private firm. A private firm was engaged by the BRO to do these activities of alignment. The private firm was not coming before this honorable court, even after multiple service of notice to them. Now they say approval came in 2023. Specific dates they have given. Approval came after this survey, 2023. BRO is saying approval of 2022. And regarding that particular period, 8 to 2020, that failure, there is a case going on. We have been able to file that annexer at that FIR at page 179. This is one issue. Another aspect, the Deputy Commissioner has also filed an affidavit. The Deputy Commissioner has categorically said that there is no field verification done from 19 to 2023. That also I'll produce, Lordship. In the name of defense, in the name of border road, are they allowed to just do anything? Unfettered rights. I'm just asking them to place whether the procedures were followed or not. If they have done it, maybe I'll have no case thereafter. But let them show that they are themselves saying, we have done, then please produce it before this honorable court. No one is restraining them from producing it. Why can't it be produced? Even today, they are not producing it. First leg of my case is the process is illegal. Second case, it is an illegal process because there are extraneous considerations been involved there. That is why you are trying to go ahead with that. My second case is that. So therefore, please have a fair mind and please go for alternate alignments, survey. Please do it. And please find out whether the route that we are proposing is appropriate or not. If it is not appropriate, we have no case. We are public at large. We cannot do anything thereafter. But please give us the opportunity of having a fair chance of showing that this is a good alignment. Why are you so hell-bent for that route to which there is nothing been followed? No process has been followed. This is our case. Basically, this is our case. I'm not against this frontier highway, national highway, defense. I'm not against anything. But I am saying give us a fair chance to produce, to say that yes, there is a route, a proper route for the public. Please use it. Or please see whether it is feasible or not. And the route that they are showing is fretted with illegalities. There is a background behind this, 12 years of failure. And now is fettered with illegalities. There's nothing on record to show that the process has been followed. The laws have been followed in toto. The Deputy Commissioner's affidavit clearly indicates there is a RTI reply by an officer of the BRO. He says there is no field verification done. I'll produce that also now. The Deputy Commissioner has Daporizu. His affidavit is there.
Mr. Kato.
So may I just also place the DC's affidavit just to complete that part?
Your affidavit
My lord.
in the main PIL.
My lord, my main affidavit, my lord.
6-7.
Please. Yes, my lord.
Para 6, para 19. And para 24.
My lord, para 6 is in respect of, my lord, the compliance of the provisions of Indian Road Congress and Indian standards guidelines, my lord.
Right.
And 19 is, my lord, in respect of, my lord, the DPR consultant, my lord, since they are also the respondent in this PIL.
Right.
And I think they have already filed their affidavit also, my lord, clarifying the stains taken by them, my lord.
Para 24.
And paragraph 24, my lord, the environment, my lord, clearance while finalizing the approved alignment and the ICR guidelines have
All
also
ICR
been- My lord, admittedly,
Right. Now please come to page number 13.
yes, my lord.
Para 34.
13 para 33, 34, my lord. Respectful, I mean, due to pendency of this present PIL, the pre-construction activities like land
Para
acquisition.
34, page 13.
My lord, 34, my lord. The statement made in paragraph 1 to 34 to this affidavit in reply are true to my knowledge,
Then
and those made in paragraph 1 to 34 are true to the information. I'm sorry, my lord, this must be clerical mistake.
so
Same paragraph, my lord, again quoted, my lord. Paragraph
No.
134 is also of the knowledge, and that again 34 is derived from the record, my lord. This
please come to page 20.
page 20, my lord, yes. Letter dated 6 August 2023, my lord.
Will you able to show para 3, appendix A, B, C? At least A.
A, we concerned with A.
My lord, also from the copy of physical field verifications conducted by both implementing agency along with copy of the various alignment explored by the DPR consultant enclosed is and
PLC are not required. A will do. Do you have A?
my lord, admittedly to pair make submission, my lord. As of now, my lord, this document is not yet produced.
Not been produced.
available in the record. Whether
Matlab
it was
that will be
forward-
available with the, matlab the more, or matlab maybe available with the both the consultant. Matlab.
Now, this letter was forwarded to the deputy commissioner, right? Upper Swansea.
Matlab.
It might be
Actually, deputy
forwarded
commissioner's
to the
affidavit is
deputy
there.
commissioner.
Matlab.
You might have forwarded to the deputy commissioner.
Matlab.
Show us. Because in that letter of 6th August or what August, down below,
6th August 2023.
enclosed as above.
Yes, ma'am.
So you might
And
have
as stated, as above, matlab.
asked them and show it to us. If
DPR
not
and
in
other
open,
things.
if not in open in seal cover, appendix A.
Matlab, admittedly, matlab, time and again, I insisted with them for furnishing of all those documents, matlab, that is not available, matlab.
Now the court
That
is
might, that must be with the deputy commissioner or the board the consultant or the ministry,
now
matlab,
the
board.
court is asking for it. If they're not listening to Mr. Kato, now we can say that.
Matlab, therefore, matlab, at this stage, matlab, for producing of the documents, maybe, matlab.
Produce that copy, appendix A.
Matlab,
We'll
we'll try to
consider.
find it out from, there must be some documents, matlab, must be available, matlab, some
You-
way, matlab, that is
It
not.
has to be a
Place it-
proper document.
We'll place it today, tomorrow we'll consider the IA.
Matlab, in that case, matlab, I'll take the,
Talk to them. Talk to them.
The one aspect, deputy commissioner has filed this affidavit. Deputy commissioner's affidavit, deputy commissioner clearly says, moreover, it is clear from the records furnished by the AE Civil BRO, no field survey, joint field survey was done along
See,
with DPR consultant.
Mr. Sharma.
This is the deputy commissioner's affidavit.
We are not on that.
Yes, Lord. Sir.
What is more concerned to us, if it is strategically advantageous for the defense purpose of the nation,
This is this.
we'll consider it indifferently. And of course, while doing so, it is also a fact that the necessary provisions have to be followed.
Which they are saying they are
It
following.
happens sometimes. You might have seen, and during the presence of the senior counsel, your father, you have also seen that the organizations act in various ways. It depends. Sometimes decisions are taken to file a case or to object it and lead it to the court where the decisions comes very belatedly, right?
Yes.
Like the court's acquisition process or whatever. Who ultimately pays? Who ultimately pays?
Public.
It is the public.
This is
In
for
fact,
public interest also.
what, with my own experience.
Yes, Lord. Sir.
The land of a tea estate was acquired in 1962 for the Chinese aggression for the defense purpose. That matter continued till the year 2020, let us say so. Then ultimately the apex court has said no. The compensation has to be paid. And defense department has paid crores and crores of rupees to the owner of the tea estate. Initially, when the matter was decided in 1965, it was hardly 3.5 lakhs.
Now
Right.
it will be in crores now.
Of course, huge area of a tea estate was taken over. And then when matter went to the apex court, up to the level of apex court, and various ways it was pending before the high court because various litigations. were there. Now, difficulty was that the defense also did not deposit the amount
Initially awarded
to
amount.
keep to the registry to earn the interest,
Yes.
right? Ultimately, who is the gainer?
Gainer is that tea estate
For the
person,
fault
but
of
then for
somebody,
at
but
at the
cannot-
cost of
see,
the
you
public.
cannot
Yes.
also object to the decision of the defense department. They also tries this way, that way, in various ways. But ultimately, the law prevails.
Yes.
And that's why the honorability estate got the result from the apex court as per the law.
Yes.
But thing is this, if this road closed or the construction did not proceed after 12 years for certain reason, there may be an inquiry, whatever is there. But what you have seen from the records here, all been time we discussed, that it was specifically placed that this road, if goes through this, the defense will be benefited. But if goes through that way, the defense will not be benefited because it is in the international boundary side.
Yes.
So
That
there is a
Mesuka side.
requirement for necessity of change the alignment.
That making it a direct alignment from Taliha to Tatu.
So there is, those are strategical decisions where the court in exercising the power of 226. The other issues which you have said, filing of an FIR of that decision taken of constructing that road. Maybe at that point of time, certain things were not brought to the notice of the authorities concerned for which that road was allowed through Mechuka and others. Now, the change of alignment, which you are saying, is again, maybe is a tough terrain, maybe or something other difficulties are there. May not be, the public may not be get such benefit.
Because there are
there's-
uninhabited area. This is a inhabited
Since
area.
if it is a case that it is only for the purpose of defense, this particular alignment is required, then you will see the court will never entertain.
Yes. But Lordship, my
Things
alignment.
are different.
Yes.
When it comes to the security of the nation, that's extra.
I understand that.
And when it comes to the,
But in the name of
public-
security, if
right, so.
and
Let
my
them show-
my case is it is for this direct alignment only. I'm not saying from Mechuka. My case is from Taliha to Tatu only.
Why
I can
they
show
have-
the map.
See, why
It's
they have,
just via a different route, but endpoints are same.
now if they have chosen to shift it through Pine now instead of.
Yes. Payang is on the left side through a mountain range, and this through Nimfu is a straight line. The map is at page 51.
that we have
Both
seen.
the
That's
both
what-
the comparisons are there. But I'm not saying a lordships to declare that this route has to be used. My case is there should be a alternate route survey, including this route. This is my case. And what I am saying is the route that you have selected, therein you have not followed the rules, which you say you have followed. This is my basic case.
It's up to Mr. Cartoon. Tell us.
The instruction of the officer.
And-
This can be proceeded.
It
Only
can-
subject to convenient date of the other council for the.
Tomorrow, day after,
Two more.
stay back. It's raining here.
It's raining in Guwahati also.
Enjoy Arunachal Pradesh. What's wrong?
I am there to assist your lordship on this matter. There's nothing on that aspect. But if they can actually produce it,
When?
If,
Tomorrow,
my-
fine. Ask them whether they can produce it
with the
tomorrow.
undertaking that they will produce, because otherwise,
We'll fix it tomorrow.
I consider the officer they have to produce it. Any dates.
But the road through Pine.
the survey, that entire field verification report.
This particular in appendix A. ma'am. And appendix B also, ma'am. C matter.
Because these are a part of the appendix to the communication to the deputy commissioner. Right? You have all this ABC, produce it ABC. You produce it tomorrow.
My,
And this was sent by, from where?
Measure,
I mean, major officer, office sitting, office coming.
Arunachal Pradesh only, APO,
It's here only.
here only. There is no issues.
Madam.
so only one thing, if I may just place, because they have to tackle this also tomorrow. So I'm just placing it for their information also. Page 20 of the deputy commissioner's affidavit,
See,
wherein the BRO has himself stated in RTI, there was no field verification report.
let us
so-
see what comes first. Let us. Tomorrow. you
Because
produce
this they will have to also tackle.
that. Let them see. Let them see tomorrow. Hardin part. Place tomorrow, enabling the BRO, response number 6. And the General Reserve, okay, GREF,
GREF.
response number 7. . to place the Appendix A, Appendix B, and Appendix C mentioned in the letter of the Major of 77 Road Construction, COY, GREF, dated 2nd August 2023, to the Deputy Commissioner, Upper Subansiri District, Dapodi, Arunachal Pradesh.
6 August.
6th, is it 6th August?
6th
Okay,
August.
06. Appendix 6. Within bracket Appendix 6, to the affidavit of the respondent number 6 and 7. In
Appendix C, I think, because the next is Appendix D.
Appendix C,
C.
to the affidavit of respondent number 6 and 7 in the present PL. We place it tomorrow. We'll see.
Oblige your lordship.
We'll come back at 2 for the single ones.
And my lord, it was submitted before this honorable court. The grievance of the petitioners would be placed before the Board of Management on 11th of July. Was it 11th of this month, my lord? It's 11/6. Now, my lord, I understand the Board of Management meeting was held, but what has happened, that information is not there yet, my lord. So I pray for adjournment, man.
Who's appearing for the Mr. Tapang is appearing? So, going to be listed.
My lord, I have no idea. I think it has to be minuted and signed. I'm not sure when they will be available.
Tell us. After vacation. Give us a date. Give us a date.
My lord.
That suits both of you.
My lord, can it be on 18th, my lord? It's reopening on 15th.
On the priority council for the parties. List on 18/7.
My lord, highly.
My lord, may I mention item number 35, my lord? I'm sorry, my lord, this is the fixed matter. The council for the, my lord, the petitioner, may be applied for the, my lord, the BC, to be conducted through BC, my lord. I'm sorry, my lord, I need to go through the record. Yesterday I reached lately, so because of the reason I could not able to go through, my lord. It is fixed matter, however, my lord.
Anyone from the petitioner is there?
In fact, I tried to contact him, but he is not picking up the call.
Okay. We'll adjourn it. If the council again joins in through
Minor.
online, it will be difficult. We'll give the date at that point of time.
May I please mention item number 9. Here, my lord, the respondent has filed an affidavit. So I would like to file a rejoinder. So may I pray that the matter may be listed after 3 weeks, my lord.
On the priority council for the petitioner. Mr. Dean. List after 3 weeks on a date to be fixed by the registrar. Okay.
Most obliged.
Worship, I beg to mention item number 13 to 28. These are all connected matter. On behalf of T. Tagum, Standing Council for Education. This matter may be fixed after 2 weeks.
Well, it has been listed for orders. Why? Any idea?
Here, we need to file counter affidavit at the department. We are yet to receive Perawai's comment from the department. Therefore,
Notice might have been issued long back. It's a 2023 matters. Any idea when notice was issued? Any idea?
last part of 2023, December,
My lord, miss.
some are
Peruse the
of
office note.
2024.
My lord, may kindly peruse the office note, because the case involved in this, there was a purportedly, allegedly, a scheme took place in recruitment of the teacher and the MTS. Now, what had happened, most of the recruitee, they render more than 2 years of service, my lord, in this case. And thereafter, the impugned terminal order is issued in violation of Wednesbury principle of law. So on the basis of that, since we have completed 2 years of our services and we are protected under Article 311 Clause 2. So without following the due process of law, without conducting departmental inquiry, you cannot initiate any action.
Your appointment was made after due advertisement and selection.
It was not, it
Then
was
how
not-
it will come, even if you have ended 2 years of service? You have seen the recent judgments of the Honorable Apex Court, whether it is state of Tripura or state of West Bengal, how the Supreme Court is dealing with.
But
Honorable
Apex Court has my lord, Apex Court equally has protected.
Protection, you see, what happened in Tripura,
Well,
right?
correct.
That's protection given to the West Bengal things a little different because the recruitment is different. And
No.
thing is this,
Correct, my lord. But my lord, kindly appreciate the Honorable Apex Court interfering with the teacher recruitment scheme of West Bengal has protected the recruitee, my lord.
because there was an advertisement, but
Ah.
here in the case, if there is no advertisement and selection, no one can be regularized. No one
No,
can go for
application
any,
was invited by them.
might be. Whether there was any selection.
In any
Inviting
case,
application doesn't mean selection.
in any case, my lord, this has to be adjudicated at
Is
relevant
there any
point.
stay order in force?
In some matter, there are stay order, in most of them, there is no stay order, notice also, sir.
Lordship, after 3 weeks.
See, taking time will not do. Thing is the.
Last
adjudication
opportunity,
of the matter.
Lordship, there are as many as 49 cases. We have filed we have filed counter affidavit in some of the cases. Now these are pending.
These are few out of 49. Do you have the list?
I don't have list now, but then
The
there
standing
are,
council, on behalf of the standing
Yeah,
council.
We understood.
Poor fellow. he
In
can't
fact-
Whom
pay.
is the standing council? Give us
Last opportunity,
other-
my lord.
give us a case number so that those cases can be list together. If this is a case that 49 cases of the similar matters are pending. Okay,
My lord, all these cases,
List, list,
probationary
list.
periods were completed, my lord.
3 weeks. On date to be fixed by the registry. Enabling the respondents in the education department to file their affidavits. It is also submitted about that the other altogether 49 cases. The similar cases are pending for adjudication. The registry shall accordingly vote them. Release those matters together with the present cases after 3 weeks. Okay,
Mashallah.
That's the last opportunity, my lord, to file contract. Great.
Lordship, I would like to mention item number 33, Your Lordship. May I kindly take up this matter on 23rd, Your Lordship. I have taken the concern of the petitioner, Your Lordship. I have some personal difficulties today, Your Lordship.
and the 2016 matter,
Yes, Your Lordship. Otherwise, tomorrow, Your Lordship. Today, Your Lordship, I have some difficulties.
okay, only for today. Only for today.
Tomorrow.
Lordship, next month, 23 July,
When do you want?
23rd July, Lordship, next month. After the-
23rd July. 2016 matter, why do you want?
Lordship, I am also responded in this case.
Who is the petitioner?
Lord, it may be fixed on 23 July, after 23 July. I'm for the petitioner.
No point. 23rd July. That's paid for the land council for the parties question. Okay,
Obliged.
May it please your lordship. Lordship, I would like to mention item number 4. It was fixed for today, but the leading council who is from Guwahati, he have instructed yesterday that he is not well. He's suffering from fever, so this matter may be adjourned. I have taken consent from the other side, your lordship.
when do you want?
After 4 weeks, your lordship, obliged.
My lordship, I beg to mention item number 5, my lordship. In this, we need to file affidavit, my lordship. So we need some more time, my lordship. 2 weeks time.
22 matters, you have not filed affidavit. What is the matter about?
Compensation
Compensation for what?
for
Equity-
selling crops and all that.
When will you file your affidavit?
2 weeks
Give us a date.
after
See,
vacation.
being a standing council, you should also follow some technique to bind the department. You should say the court has fixed it, so you have to file your affidavit. Yes, give us a date by which you will file your affidavit. Yesterday, we have said that the department should not sit over your head. You should sit over their head.
22nd July, my lordship.
22nd July is more than a month.
Then
You file it immediately after vacation. That
Okay.
will give us a date as the reason.
17 July.
Okay. List on 19 July.
19.
In the evening, why? The respondents shall file their affidavits in the matter on or before 17/07/2024, serving a copy of the same on the council for the petitioners. Okay.
I beg to mention item number 3.
Yes.
Seeking adjournment on the behalf of leading counsel K. Dabi due to his medical issue. And I have taken the consent from the other side also.
When do you want?
After 4 weeks.
As Mr. Kedabi, leading counsel for the petition and is in disposal. Unless this matter after 4 weeks, and it will be fixed with the history. Only prayer of the council for the disposal, unless this matter. Okay.
Your Lordship, I beg to mention one pending matter for tomorrow.
What's the matter about?
Pending matter is service matter, Your Lordship, for withdrawal.
Withdrawal. Come. Okay.
God bless you.
May I please, Your Lordship, I beg to mention item number 8. So in this matter, we have to file rejoinder affidavit. So we may given 2 weeks of time to file
We are going to file the rejoinder.
rejoinder affidavit, sir.
When the opposite parties have filed the affidavit.
Yes, Your Lordship.
When? When did you file your? Okay. When are you going to file your rejoinder?
After 2 weeks, Your Lordship.
Give us a date.
June, sir.
Petitioner is allowed to file rejoinder to the affidavit of the state respondents on or before 16th July. List on 18th. Okay.
Please, Your Lordship.
Without field as the respondents have filed affidavit way back in the year 2020. So, thank you, sir. Yes.
Item number 30.
30.
Therein, we are required to file an additional affidavit to bring on record certain documents of the bid. And there's been also a joint prayer from the other side also. They're also seeking some time. So if Your Lordship can have it on 27
Which month?
this month. Because otherwise a tender matter, there's no stay order, there's some urgency. But the fact is that there are some documents that I need to bring on record. Otherwise, it will not be proper. Twenty-seventh is Thursday.
You submit on or before 27th?
Yes, Lordship, that we'll have to do. That I will do.
But when to be listed?
On 27th. We can file it in a day or two, this affidavit.
27.
Let it be on 27 for appropriate hearing.
Okay.
Obliged, Lordship.
Lordship, I beg to mention item number 10, my lord.
Yes.
Yes, my lord, respondent number 1 and 2 is still yet to file an affidavit in opposition.
You are for the respondent?
Yes, I am for the petitioner.
Who is for the respondent?
So,
Any department? Which department?
land, my
Which
lord,
department?
land, my lord, land.
Land management?
Yes, my.
Yes.
May I please, Your Lordship, I'm appearing for respondent number 4 here. We have filed our affidavit, Your Lordship.
Who is appearing for the land management department?
Mr. M come to this standing council, Your Lordship.
Not here.
Yes,
D come to, sir.
yes, my lord, I consent.
Okay, we'll pass the order. Let the matter reach. We'll pass the order. Let us see who appears. We'll pass the order. Who is here? Are you appearing here? In item number 10? Okay.
10. Yes, my lord.
It seems you have not filed your affidavit.
Give me one second.
What was it?
My lord,
22 matter, you have not filed your affidavit in.
my lord, some parallel comment has come, my lord, in this matter, my lord. We will be filing, my lord.
File.
Okay.
We'll dismiss this petition. There are two affidavits filed by the respondents. One by the respondent number 4. That was filed on 12th of March 2024. The another affidavit was filed by respondent numbers 2, 3, and 6. That was filed on 15th of June 2023. And clearly mentioned in the affidavit that one Biri Kagum,
Yes, my lord.
one Biri claims to be the actual owner of the land involved in the case, not the petitioners. In such disputed question of facts, we cannot entertain a petition.
And you have not filed any reply to the affidavits of the respondents. Tell us what to do. A clear mention in the affidavit of the respondent number 2, 3, and 6. So,
Yes, my lord, my lord is then, my lord's council is, my lord, litiging council is in, out of the station, so. This matter will be,
Monday.
another address will be big.
Monday.
Okay, man.
The respondent numbers 2, 3, 6, 2, 6. Two, 3, 6. 2, 3 numerical angle, 6 A and D angle, 4. I've already filed their respective affidavits. The respondent number 1. My lord, already made submission that no counter affidavit from the side of the respondent number 1. Is required to be filed and shall rely upon the affidavit of the other respondents. In view of the above, list this matter for admission on Monday, the 24th. Okay, it will come on 24th.
May I please, Your Lordship? I beg to mention item number 29 of order, Your Lordship. In this case, Your Lordship, I'm appearing for official respondent number 2, 3, and 4, Your Lordship. We are yet to receive our instructions, Your Lordship. For that, Your Lordship, we need some time, Your Lordship, for filing our affidavit.
Tell us when you will file your affidavit.
Yes, Your Lordship.
When will you file your affidavit?
By 3 weeks, Your Lordship.
Give us a date. Give us a date.
By Your Lordship. 22 July, Your Lordship.
Why it is so favorable for all? Is there some special?
Otherwise, Your Lordship, I was praying for 3 weeks time, Your Lordship, for filing an affidavit. Because no instructions have been received. Your Lordship.
Which respondent?
2, 3, and 4 official respondent, Your Lordship. State respondent.
Which department?
DC UPI, Your Lordship. DC UPI and DLRSO UPI.
Item 29.
Yes, Your Lordship.
When the notice was issued?
Notice was issued on 22nd of December 2023. Your Lordship. December 2023. Your Lordship.
Notice in this case was issued in December 2023. In the respondent number 2, 3, and 4 shall file its affidavits in the matter on or before 19th July. List on 22nd.
Yes. My lord.
Obliged.
My lord, I mentioned to another matter, item number 38, my lord.
Item number
38, my lord.
38, yes.
Yes, my lord.
Yes.
Yes, today I'm not ready to prepare. I'm not prepared.
So that matter will fix for after 1 week.
On the, have you informed the other side?
Yeah, I informed.
After 3 weeks and it to be fixed by the registry. In the prayer of the council for the parties going. Okay.
Apply.
Mayor, Manoj, I would like to mention item number 32, Manoj. 32, I am for the petitioner, Manoj.
Yes.
I have an instruction to file amendment application, Manoj, so I will take some time, Manoj. So
You have not yet filed.
Not yet filed, Manoj. After 2 weeks, Manoj, please.
Give us a date. By which date you will file your amendment application? Application for amendment or
Yes,
amended?
amendment application.
Amended or application for amendment?
Application for amendment. So after what, 2
Why
weeks?
do you need to file the application for amendment? What happened?
Manoj, Manoj, issue I have not raised, Manoj. I would like to include
Withdraw it, file afresh.
Well, I have challenged the memorandum, Manoj.
Challenge it again.
Manoj.
Why do you need to file an amendment application?
Because I have left it out, Manoj.
You withdraw it, file a fresh application, taking a liberty.
Manoj.
That's a better way.
Yes, Manoj.
Otherwise, you have to seek an application for amendment, then you will be filing an amended petition.
Yes, Manoj.
If some issues are left out, you can record it.
Alright.
We can grant you liberty to file afresh.
Alright.
Up to you.
Alright. I have only instruction to Manoj, seek time for amendment application. Maybe listed after a week then, Manoj, so that I can take proper instruction on.
Okay.
I have also suggested for withdrawal, Manoj.
That's seeking liberty you file. Sometimes it happens, you know, some issues may not be incorporated in a petition. Tell us when. It seems your senior has become minister.
No, Manoj. I am leading the case, Manoj.
Okay. Okay. When do you want?
Manoj, on 20.
Okay, Monday.
27, Manoj.
No, not that much. For instruction, you don't need so much time.
Manoj.
Okay, on 25th.
Yes, Manoj. Thank you.
The prayer of the council for the petition of list on 25th. Okay. So what remains in the list? What remains in the list?
Motion.
Is it because? Let's see.
Obligation.
Motion.
Your Lordship, I beg to mention item number 6. Positions as filed by the respondent number 3 and 4. So I may be allowed to file rejoinder.
Who filed the affidavit yesterday?
Respondent number 3 and 4.
3 and 4.
Private respondent 3 and 4.
What's your good name?
Tabatukur.
It is submitted that the respondent number 3 and 4. Within bracket private respondents. Filed their affidavits yesterday. So, Mr. Tabatukur, learned counsel appearing for the petitioner. Prays for some time to file rejoinder. Prayer allowed. Petitioner shall file such rejoinder. On or before 19 July 24th for admission.
In the meantime, your Lordship, intimation may be continued.
Till the next date of listing. The interim order posterior shall remain in force.
Chief, Your Lordship.
Yes,
Well, instructions were called for.
that's what we want to know. When did the petitioner participated in the disciplinary proceeding? Give us the dates or give us the record, we'll see.
My lord, yesterday I went to, the authorities were not present, but they sent the reports to us.
Yeah, wait, one.
उसको information वाला but then
You know what, yes.
oh,
13, maybe 13. Nick? Thirty percent. 22.5.
But you said that the inquiry is already over and submitted a report.
yes. And
Well-
my lord, after submission of the report, the executive council has passed an order. That is in
Give it
last
to us,
page.
give it to us.
Last page. Last page. It is in the last page. At item number 58.
Item number?
58. It is a
Last page.
Yes,
yes, may I read it?
just a minute. See, we wanted to know the dates on which the petitioner appeared before the inquiry committee.
Article of charge is not here, man. Article of charges. Article of charge.
That is
But,
nothing, so we wanted to
inquiry
know.
committee report is here. Inquiry committee report.
We, okay, give it to us.
Yeah, record me.
Madam medical man.
One minute.
Inquiry officer. Inquiry officer.
Take your seats, take your seats. Heard Mr. T. Tara, learned counsel appearing for the petitioner. Also heard, who is for the Union of India?
Mr. Kato, pro forma only, but the main is
Mr. Kato, learned deputy SJ. Order number 1. And Mr. T. Gadi, learned standing counsel, Rajiv Gandhi University. Order response numbers 2 to 4. Person to an affair dated 25/09/2023, lost by the informant Srimati Kekum Lombi before the Women Police Station in Jalnagar, alleging that the petitioner associate professor. Which department?
commerce.
Department of Commerce, Rajiv Gandhi University. 124/09/2023. When her daughter between 4, just I marked it at page number 26. When her minor daughter, aged about 6 years, visited the house of the petitioner, come on, associate professor, Department of Commerce, Rajiv Gandhi University. To play with the daughter of the petitioner, comma, he would back the petition. Page number 26, I have marked it, just put it there. Okay. After filing the said complaint, Itanagar Women Police Station, case number, said complaint on 25/09/20, Itanagar Women Police Station case number, Women Police Station Itanagar case number 93/2023 under section 376 IPC reviewed section 4 of the POCSO Act was registered, and the petitioner was taken into custody on 25/09/2023 itself. And detained in the custody for more than 48 hours. As such, the authorities of the Rajiv Gandhi RGU, by order dated 29/09/2023, suspended him from service directing him not to leave the headquarters of the RGU without obtaining prior permission from the competent authority. After investigating the case, police submitted charge sheet in said woman WPS, Women Police Station, Itanagar, case number 93/2023 on 21/12/2023, white charge sheet number 156/2023. With the charge under section 376 IPC, reviewed section 4 of the POCSO Act against the petitioner. Accordingly, POCSO case number 02/2024 was registered in the court of Special Judge within bracket POCSO, Papampuri District, Arunachal Pradesh, UP, arising out of said Itanagar Women Police Station case number 93/2023. And charged under section 376 of the IPC, reading section 4 of the POCSO, was framed against the petition. The Just right. However, the trial of the said case before the special court within bracket POCSO has not yet been started. Mr. Tara, when he was released from bail, any idea?
Well, in my let's see which date of release.
Oh, don't write, SAR is not yet framed. And 20/06/2024 is the date fixed for framing of charge in the said special case, such and such case. You were released on bail, I think so.
Yes, my lord. 7th February was the date of release.
Later, the petitioner was released on bail and said special case number POCSO case number 02/2024. During the pendency of said POCSO case number 02/2024, the respondent university on 14/04/2024 issued memorandum of charges to the petitioner with the following article. Yes. That the petitioner committed a sexual assault upon on the minor girl, page number 61, just note down, just note it from there, you note it down. Within bracket, daughter of such and such. On 24/09/2023, inside the premises of the university. Along with the said memorandum of charge, the respondent dated 14/04/2024, the respondent university have also incorporated the statement of imputation of misconduct or misbehavior in support of the article of charge framed against him as well as comments. Proposed during the inquiry and the list of witnesses in the said inquiry as annexes 2, 3, and 4, all Roman, directing the petitioner to submit his reply, if any, within 10 days from the receipt of the said memorandum of charge dated 14/04/2024. On receipt of such memorandum charge from the respondent university, the petitioner on 17/04/2024 submitted his written reply. Denying all the allegations lodged against him with regard to the incident involved in the case. The petitioner on 03/06/2024 also filed a representation before the registrar of the respondent university
Arjun.
before that, on 3rd June, such and such, registrar of the university, to suspend oblique stay the departmental inquiry initiated on 14/04/2024 till conclusion of the trial, said POCSO case number 02/2024, presently pending before the special judge POCSO. POCSO is within bracket, Papumpari district, UP, Arunachal Pradesh. Stating that the criminal action relating to said POCSO case number 02/2024 against him, as well as the disciplinary proceeding initiated by the respondent university against him, are on same set of facts and grounds relying on the decision of the Honorable Supreme Court in the case of Kusheshwar Dubey versus Messrs. Bharat Cooking Coal Limited and others, reported in 1988 for SSA 319, as well as in the case of Captain M. Paul Anthony versus Bharat Gold Mines Limited and another, reported in 1999, 3 SSA 679. The petitioners submitted before the respondent authority that the respondent university, that since the criminal action and the disciplinary proceeding are grounded upon the same set of facts. Therefore, the proceedings and the disciplinary proceeding initiated against him by the respondent university should be stayed. As the respondent university did not reply to the said representation of the petitioner dated 03/06/2024, the petitioner has filed this petition on
10/6.
14.
3/6. 3/6/2024.
14/06/2024.
Yes.
Praying amongst others, a direction to the respondent, Rajiv Gandhi University, to set aside in costs the operation of the impugned departmental inquiry initiated against him by issuing the memorandum of charges dated 14/04/2024, and not to proceed with the said proceeding, said departmental proceeding initiated against him till the conclusion of the regular criminal trial by the Special Court UPA, Special Court within the POCSO UPA, in connection with UPA case number 22/02/2024. That you have already written, I think, so the case number. Special. Oh, the POCSO case number 02/2024, arising out of Itanagar Women Police Station case number 09/2023, pending before the special judge within bracket POCSO, Papumpara district, UP of Arunachal Pradesh. Ms. Satara, learned counsel appearing for the petitioner, relying on the decision of the Honorable Supreme Court in the case of Professor Dubey, Supra, as well as
Well, also the coordinate bench judgment of this court.
yes, Captain M. Paul Anthony, Supra, and a decision of a coordinate bench of this court in the case of Lalit Kumar Singh, SINGH, versus Arunachal Pradesh Rural Bank and others, reported in 2022 within bracket 2 GLT 184. Submitted that the disciplinary proceeding initiated against the petitioner by the respondent Rajiv Gandhi University on 1404/2024 issuing memorandum of charges against him needs to be interpreted by this court. On hearing the submission of Mr. Tara, because of it. Before that. After that, please. During the deliberation of the matter, Mr. Gadil and its standing counsel for the responding university apprised the court that the concerned inquiry officer already submitted the inquiry report before the disciplinary authority of the respondent Rajiv Gandhi University pursuant to the disciplinary proceeding initiated against the petitioner by memorandum of charges dated 14/04/2024. As such, by order dated 17/06/2024, we directed the respondent university to apprise the court as to when the petitioner appeared before the concerned inquiry officer and as to when the inquiry officer submitted its inquiry report before the disciplinary authority of the respondent university. And fix the matter today. Mr. Gandhi, learned standing counsel of the respondent university, placed before the court that the petitioner appeared before the inquiry officer on 13/05/2024 and the and on 16/05/2024. The statement of the petitioner as well as other witnesses were recorded by the inquiry officer. Just a minute. On 16/05/2024 in presence of the petitioner. It is also placed before the court by Mr. Gadi, standing counsel of the respondent university, that on 2205-2024, the inquiry officer directed the petitioner to submit his written response within a period of 24 hours from the date of received of the communication, asking him to respond on the following queries. I marked it. Queries 1 and 2. It is also placed before the court that the petitioner received the said communication of the inquiry officer dated 2205-2024 on 2205-2024 itself. Mr. Gadi submitted that the petitioner did not file his any written response to the queries made by the inquiry officer on 2205-2024. And the inquiry officer on 30/05/2024 submitted its inquiry report before the disciplinary authority of the responding university. To that extent, Mr. Gadi placed before the court the copy of the appointment of the inquiry officer as well as presenting officer by the respondent university with regard to the disciplinary inquiry initiated against the petitioner by the respondent university. Appointment of inquiry prisoner by notification dated 31/03/2024. The receipt of letter dated 13/05/2024 by the petitioner from the inquiry officer regarding the inquiry dated 16/05/2024. That means Mr. Gadi, Standing Counsel of the respondent university, also placed before the court that on 14/06/2024, the Executive Council of the respondent university accepted the report of the inquiry committee submitted on 30/05/2024. with regard to the allegation of sexual assault and harassment and molestation of a minor child by the petitioner. And the matter is now pending for obtaining legal opinion by the said university pertaining to imposition of major penalties as per the 11 rules of CCS, within bracket CCA, upon the petitioner.
From record, it appears no penalty has been imposed, it seems.
Since the disciplinary inquiry against the petitioner with regard to the memorandum of charges dated 14/04/2024 issued by the respondent university pertaining to the allegation of sexual assault, harassment and molestation of a minor child on 24/09/2023 in the quarter of the respondent university is already over, during which the petitioner did not object regarding such inquiry pertaining to the memorandum of charge dated 14/04/2024 issued by the respondent university. The prayer of the petitioner for setting aside or setting aside into pause the said departmental inquiry dated 14/04/2024 and not to proceed with the departmental proceeding initiated against him on the basis of said memorandum of charge dated 14/04/2024 cannot be considered. It is also seen that the trial of said POCSO case number 02/2024 has not yet been started. Moreover, from the search sheet of said
CC is fixed tomorrow, my lord.
Is it
Yes,
22?
CC is fixed tomorrow. The trial is commenced already, my lord.
Evidence not recorded. Evidence is yet to be recorded.
Where is that? Where is the order?
Evidence is yet to be recorded.
58.
From the search sheet file inside. Search sheet dated 21/12/2023. File inside Itanagar Urban Police Station case number 93/2023. We have seen that there are altogether 14 witnesses including the informant, the victim, daughters of the petitioner, wife of the petitioner,
You have told me that there is some.
and others. But from the inquiry report placed before the court by Mr. Gadil and standing counsel, respondent university, we have seen that the inquiry officer recorded the statement of the informant, her husband, their minor victim, both the daughters of the petitioner, the petitioner himself, and two neighbors of both the petitioner and the informant, and also a professor of the said university from the Department of Commerce. Of the respondent university. And all such recording of statement of the witnesses were made in presence of the petitioner. For such reasons, this court is of the view that before that we put one time, it is well settled that a trial in a criminal case as well as trial in a disciplinary proceeding are two different propositions. In the court of law, with regard to criminal trial, The same is to be proved by the state beyond all reasonable doubt. Whereas in service law, with regard to any disciplinary proceeding, it is preponderance of the probabilities. Considering entire facts and circumstances stated above, this court is of the view that the propositions of law laid down by the Honorable Apex Court in the case of such and such Bhutili Supra will not be applicable in the present case, since the petitioner, without any objection, appeared before the disciplinary inquiry of the respondent university initiated against him pursuant to the memorandum of charge dated 1404.
My lord will record, nevertheless, a prayer for a stay of suspension was submitted by the petitioner on 3rd June 2024.
2024. Whereas he submitted his representation before the respondent university, authorities of the respondent university, only on 3rd June 2024, much after the submission of the inquiry report by the concerned inquiring officer. Accordingly,
Well, my lord, I also request my lord to add one more paragraph. Since my lord is not dismissing the read petition, well, my lord will clarify, it is, Mr. Tara has contended that when the disciplinary proceedings and the criminal proceedings are grounded on the same set of facts, it is desirable to stay the departmental proceeding as what is held in
Tara, that you have
para
sent-
7 and 8 of the Kasevar Singh,
Yes.
Kasevar Deka.
Jasmine
Dubey
Khan
case.
mentioned,
Huh.
Mr. Tara relying upon, you have already said, I think so. Relying upon that should have been stated, put that line. We'll correct it.
Correct. I am relying on para 7 and 8.
Yes, yes, yes.
Yes. Grateful, madam.
Dismissed.
May additional option. Lordship, on 17, when this matter came up, Lordship,
Yes,
after the appearance entered by the committee, Lordship, this matter was again listed today.
we have made him a party here now.
Lordship,
Not yet.
not yet party. As to my humble understanding, Lordship, in order to make a party, Lordship, the party who's effecting the order passed by this honorable, he has to file an IA to implead himself in the proceeding, Lordship. That is my humble understanding, Lordship.
Here is the order.
Lordship. Lordship, order passed on.
Have you gone through the order?
Yes, Lordship.
We direct you to make him a party.
After perusing of the order, Lordship,
He's appearing for the caveat. Heard Mr. H.K. Zemon, right?
Right.
Grant counsel for the caveator. Caveat stands discharged. This is writing the caveat. Have you served copies on the caveat?
Lots.
During the deliberation of the matter, your good name,
Igaram, Lordship.
counsel for the petitioner submitted that a copy of this writ petition along with the annexes have been already served upon Mr. H.K. Jam, counsel for the caveator. However, the caveator has not yet been made a party respondent in the present proceeding. As such, caveator is directed to file an appropriate application for incorporation of his name as a party respondent in the present proceeding. Such application shall be filed on or before Friday. Not necessarily. You can do it by yourself. You can file it through your advocate's clerk, nothing else. Based on Monday. That's almost. Well, it's a very short application.
Deeply obliged.
Item number 1 and 2.
My lord, I'm appearing on behalf of M. Cutoff on for the Union of India. My lord, we have not filed the affidavit yet. My lord, we have not received any instruction from the department. Communication has been made.
What is your prayer here?
Might give some more time. We will
What
take
is your
instruction.
prayer here?
We'll take
This
instruction from.
petition.
My lord, I'm the petitioner, my lord.
You are the petitioner.
Yes, my lord. My lord, it pertains to the compensation, my lord. In fact, my lord, compensation, my lord.
Compensation?
Yes.
What happened?
My lord, the lane was acquired, my lord, and there was a proposal for construction of two by lane from Balipara Chadwa to Tawang, man. Now thereafter, the lane was acquired, my lord. The compensation was paid, man. But however, there were so many discrepancies in the compensation.
Just a minute. Now, where is the preliminary notification for acquisition of your land?
No, my lord, that is not my case, my lord. That is not my case, my lord. Now, when that happened, my lord, there were so many discrepancies, my lord. Therefore, my lord, certain two writ petitions were filed, my lord, praying for CBI inquiry, my lord. And there was a direction from the Honorable Court for a CBI inquiry. And there was a direction to the state authorities to re-verify the compensation awards, my lord. Now, after re-verification, what it has been found, my lord, and it was to be done under the new act, my lord, the LAR Act 2013.
No, but just first tell us whether your land was acquired. Whether your land was acquired.
Yes, my lord, because the land.
Where is that notification and declaration that your land has been acquired or taken over?
My lord, I'm not challenging the thing, my lord. I'm only agree with the manner in which the compensation was paid, my lord.
That is the reason we are asking you.
Yes, madam.
If you are not satisfied with the compensation assessment.
Yes, my lord.
Where is the notification?
Notification, I'm not annexed, my lord, because I'm not concerned with the notification, my lord.
Have you received compensation?
Yes, I've received, my lord.
On what basis?
But that was challenged, my lord.
And there was again, there was a direction from His Honorable Court to re-verify the compensation, my lord, which was sweet, my lord.
When did you receive the compensation?
My lord,
When did you receive compensation?
back in 2012, my lord. 2012.
2012.
Yes, my lord. Now, in 2015, we filed a writ petition. 2 writ petitions were filed, my lord. And there was a direction, my lord.
The old and the new both.
Old one, land acquisition.
You received compensation on 2012.
my lord. Yes, ma'am.
When this new act came into force?
2013, my lord.
So if you have received compensation in the year 2012,
Yes, my lord.
that means your land was acquired prior to the coming of the new act.
My lord, that's true, my lord.
Is there any possibility that your assessment shall be made in this new act?
My lord, there are notifications from the state government where they have accepted that the reassessment will be done under the new act, my lord. So it was done in the new act, my lord.
Reassessment done to be new act?
Yes, my lord.
When possible?
No,
Before coming into the force of the law or after coming into the force?
After coming into the force.
And when your land was acquired?
My lord, here, my lord, there was a direction from this honorable court.
We are asking you.
Yes, my lord.
This is a court of law. Certain things has to be set in right.
Yes.
If some land has been acquired during the force of the previous act.
Yes, ma'am.
Compensation has been paid during the force of the said act.
Yes, ma'am.
Can there be a redetermination in the new act? Because
Therefore,
if some notification has also been issued
yes, ma'am.
by the government,
Yes.
is it possible that the land that was been acquired in the previous act, compensation paid in the previous act, now to be redetermined under the new act?
Yeah.
Under which provisions of law the new act provides that?
My lord, if
kindly show us the new provisions where the new act will come into force and applicable with regard to whose cases, which cases?
Section 24, if there is a left in that all act, my lord.
Section 24. Kindly read section 24.
Land acquisition process under so and so shall deemed to be have lapse in certain cases.
Kindly read.
Notwithstanding anything contained in this act, any case of land acquisition proceeding initiated under the Land Acquisition Act so and so, A, where no award under section 11 of the said Land Acquisition Act has been made, then all provisions of the act relating to the determination of compensation shall apply. Or where an award under the said section 11 has been made, then such proceedings shall continue under the provisions of the said act, said Land Acquisition Act, as if the act has not been repealed. Nothing, notwithstanding anything contained in the subsection 1 in case of land acquisition proceeding initiated under the Land Acquisition Act 1984, where an award under this set section 11 has been made 5 years or more prior to the commencement of the site, but the physical position of the land has not been taken or the compensation has not been paid to the said proceeding shall be deemed to have been lapsed, and the appropriate government, if it so chooses, shall initiate the proceeding of such land acquisition fresh in accordance with the provisions of this act, provided that where an award has been made and compensation is in respect of a majority of the land holdings has not been deposited in the account of the beneficiaries, then all beneficiaries specified in the notification for acquisition under section 4 of the said Land Acquisition Act shall be entitled to compensation in accordance with the provisions of this act.
So you fall under which category?
No, my lord, I'm
In under the, because only section 24 provides the grounds where the provisions of the Land Acquisition Act 1894 will be deemed to be lapsed, right?
yes, my lord.
So you kindly tell us that you fall under this particular
My lord,
category.
this is not my case, my lord. My case is different, my lord.
You are there for reassessment, right?
No, my lord, I'm not for the reassessment. Therefore, my lord, if my
What
lord,
is your case? Tell us.
if my lord permits, my lord.
Yes.
Now, there was certain discrepancies in the acquisition process and in the value of the assessment, my lord. Some were paid, but some were not paid, my lord. Then some people were paid, some beneficiaries were paid, but others were not paid. Now, in between, there was two petitions were filed, my lord, before the Honorable Court. And there was a direction from this Honorable Court to for investigation to be made by the CBI. And also there was a direction to the state respondent. If my lord turns to page 29 of my 23 of my.
Just a minute. Okay. Which page?
No, page 23, my lord. Two repetitions were filed, my lord, after the lane was acquired and the compensation was paid. Page 23, my lord, is the repetition, my lord. The first repetition, 154 of 2012, my lord. Relevant part, my lord, would find at page 38, my lord, para 14. Bear with, my lord. In view of the above findings, it is beyond doubt that it is a fit case where a CBI inquiry could be ordered. It is accordingly directed that the CBI shall make an inquiry into the matter to find out the truth or otherwise on the alleged irregularities committed by the members of the board and other persons, including the local MLA, within a period of 6 months from the date of receipt of this order. A copy of the order along with the copy of the writ petition with annexures apprehended thereto shall be furnished to the CBI by the registry of this court. After submission of the report, the CBI shall take necessary action against the persons, officials found involved in the commission of the irregularities and fraud in accordance with law. It is also directed that the Chief Secretary of the Government of Arunachal Pradesh, respondent number 1, shall constitute a new compensation board with Deputy Commissioner of West Kameng District, Bombila, as its chairman and 3 other responsible officers of the rank of Deputy Secretary of the Department of Revenue, Agriculture and PWD to collect assessment of valuation of the properties involved and submit fresh report before the authorities concerned within a reasonable period, preferably within 3 months from the date of receipt of copy of this order. The registry shall communicate the order to the CBI authority and the Chief Secretary of the Government of Arunachal Pradesh furnish them with a copy of the writ petition, including the access apprehended thereto, and the copy of the revised comments dated so and so, submitted by Sri so and so CEO in charge, Additional Deputy Commissioner Diram, which was placed before this court at the time of hearing for fit manner. Now, according,
Then what happened?
now, accordingly, my lord, a new board was constituted, my lord, and a reassessment was made, my lord, and in pursuance of this order is an honorable court, my lord. Now, under that new assessment was done under the LAR Act, 2013 Act. 2013 Act. Under the new Act.
Page.
The notification, my lord. Page 47, my lord. 2017, my lord.
So the land was again acquired.
No, lane was again, because there was a lot of discrepancies in the assessment, my lord, and the severe inquiry was conducted. Therefore, my lord, it was directed for a reassessment by a new board, my lord. Earlier it was done by the ADC. Now it was directed that the Deputy Commissioner of Concerned District would constitute a board and he will be the chairman and it will be done under the new act. There is no specific direction from the Honorable Court, but then the state decided that it would be done under the new act, my lord. Now, that was done. When it was done under the new act, my lord is well aware, my lord. Section 30 of the LAR Act says, my lord, 100% solution is to be given, my lord. Now, under the new act, it was assessed under the new act, valued under the new act, but we were denied the 100% solution, my lord. Saying that since we have been paid compensation, 100% solution has not been given to us, my lord. But to the other similarly situated persons, madam. There is my grievance, madam.
What is the regulations? Give us the regulations, 1947 regulation. Arunachal Pradesh codes were there, no? AP code. We need Zoom land regulation. Zoom land regulation.
Volume 7, no?
In this side, I think so. This side. Frontier tract. Give us the volumes. I'll try to find out. Give us the volumes. Not in this volume. Any other volume? Any other volume available here? Only this volume. What will be in some other volume? The old volume, because 1947, no? First two volumes will get it. First two. Only one should be in this.
1947 or that.
This is available here. So, first volume.
What is the compensation to be paid under the provisions of this? Frontier Tract Land Regulation 1947.
The total amount which have been paid, my lord.
Under the provisions of the Zoom Land Regulation 1947, what is the compensation to be paid and to whom?
That, my lord,
You are relying on this particular notification of 9 December 2017, right?
yes, my lord.
Now, the land was acquired
Yes, my lord.
under the provisions of the Frontier Tract Zoom Land Regulation 1947.
Yes, my lord.
Now just tell us, what is the amount of compensation to be paid under the said 1947 regulation?
That I'm
And
not
to
aware of.
whom it is to be paid?
To the beneficiary, my lord. I'm a beneficiary here, my lord.
To whom and what is the amount?
That I'm not aware, my lord.
Yes. Then,
my lord, they have, my lord, my case is that, my lord, I've been paid, my lord. I am not asking for the solution on, but here the question, my grievances is that, my lord, the other persons, this 100% solution had, under the new act has been paid by pick and choose basis, my lord.
okay. What is the reply given by the government?
Yes, my lord.
What is the reply of the government?
Government, my lord, they have accepted, but they say since we have been already paid, they cannot pay, my lord. But it is very apparent from the.
What is the reply of non-payment of the 100% solution?
They say that we have been already paid since 2012, my lord.
When you have been paid?
2012, back in 2012.
Now this 2017 notification is applicable for whom?
For the reassessment, my lord. It was again reassessed, my lord.
This page 47 notification.
Yes, my lord.
You come under this jurisdiction?
Yes, my lord. Because the entire stretch of the lane was reassessed, my lord.
Yes, who is appearing for the land department? You are appearing?
My lord, yes, my lord, but the affidavit of Deputy Commissioner, my lord, it is more important, my lord, because all the exercise was carried out by under him as a chairman of the committee, my lord. And my lord, my file, Ms. Authority, my lord, she was waiting for this matter to come up, my lord. But due to some personal difficulty, my lord, there is, it will be more appropriate, my lord, if
Will be appearing for the deputy commissioner.
Ms. J. Adjamal.
Okay. Now, any assessment made by the deputy commissioner, whether he can own or the land management department has to give its approval.
No, my lord, it was done by a board, my lord.
The decision of the board headed by the deputy commissioner, right?
Yes,
whether the land management department of the state is required to give its approval or not.
Yes, my lord.
Now, during such approval of the land management department, whether the solicium of 100% was incorporated in that
No, my lord.
compensation amount or not.
No, because, my lord, this second assessment, my lord, which is carried up on the direction of this honorable court, my lord, in the earlier report, it was not sent to the government, my lord. Therefore,
It was not sent to the government, then
Yes,
how the deputy commissioner can pay? Without the approval of the government?
my lord,
Any award without the approval of the government, is it possible?
award actually, my lord, it should be from the government, my lord, but in
What happened? Yes.
in the district, my
Then
lord,
where
some
from
of
the money came?
deputy commissioner, my lord,
Where from the money came?
many money, my lord, it is from the, my lord, Ministry of MORT, my lord.
Hmm? Without the award being approved by the government, the deputy commissioner obtained money from the requiring authority
This,
and
my lord, this
money was disposed of.
earlier, this acquisition,
Hmm.
my lord. It was prior to coming into force of 2013 Act, my lord.
Hmm.
And even the land was acquired before the coming into force of the 2013 Act, my lord.
That's right.
And accordingly, even the compensations
Hmm.
to the affected family, they were given compensation in the year 2012.
Hmm. Do you have that award
My lord,
that was initiated under the Land Acquisition Act?
that award, my lord, that award, my lord, should be in the affidavit filed by the deputy commissioner, my lord. So therefore, my lord, award is, my lord, given by the then acquisition commissioner, my lord, who is the deputy commissioner in the district, my lord.
Now, my lord, if my lord peruse the
Tell us.
yeah, my lord, if you see that affidavit filed by the government, my lord, the land was secured under the Balipara Act, my lord, but the compensation was determined way back in 2012, my lord, under the LA Act 1894, my lord, and the reassessment was done under the new act,
Under which provisions of law?
my lord.
Under which
No,
provisions of law?
as per their documents, my lord. Secured under the Balipara 1947 Act, compensation estimated prepared under the LA Act, and the new assessment was done under the new Act, 2013 Act. Page 79 of their affidavit, man, the government affidavit, man.
Okay, then Madam Ate be here tomorrow.
The affidavit filed by the government, man.
Let her be here.
page 79, my lord. Down below, my lord, will find that there was it was a request from the deputy commissioner, who was the chairman of the board, requesting the commissioner land management to acquire the land under the new act, LAR Act, 2013 Act.
Okay, let Miss Ete be here.
Madam. Well, I'm only agree with the manner in which the reassessment was done and the compensation was paid. Because
Tomorrow or day after?
My lord,
next Tuesday,
here, requested me to be, data matter is included. Miss Ete, my lord, she has requested me to get the matter fixed on 25th of this month, madam.
No. You have heard. Ask her to be here day after tomorrow. We'll take it up day after tomorrow. Buddha matters,
Tomorrow, madam.
day after tomorrow. Yes.
May I beg your lordship? Your lordship, this matter pertains to registration of a society and the renewal of the certificate. The impugn renewal certificate is at page number 46. Actually, basically, your lordship, this is a matter wherein two groups of people of a society, your lordship. They were having a fraction, because of which, your lordship, there was a order which was passed by deputy commissioner. Your lordship may kindly come to page number 24, your lordship, annexure 2. It's dated 4/1/2021. Herein, your lordship, the renewal certificate, which was given in favor of the respondents herein, it was cancelled, your lordship. Thereafter, your lordship, they approached before this honorable High Court, your lordship. This honorable High Court, after that, upon hearing the writ petition, your lordship, directed the parties to approach Court of Civil Competent Jurisdiction. Subsequently, we approached before the Civil Just Junior Division at UPIA. We filed a title suit bearing number 12 of 2021, in which we also filed a connected interlocutory application 137 of 2021, which and the order dated 21/12/2021 was passed in our favor, whereby the petitioner hearing, they were given the right to function as the executive members of this particular society. While this order of this civil judge, Your Lordship, order dated 21/12/2021, while it was still on standing, the respondents here in Your Lordship, they approached before the Deputy Commissioner and the Registrar of the Societies, and they obtained the impugned renewal certificate, Your Lordship, which is challenged here in Your Lordship.
Page 46.
Pardon, Your Lordship.
Page 46.
Yes, Your Lordship. This is the impugned renewal certificate, Your Lordship,
Then-
which the respondents have obtained, Your Lordship. This is in challenge. This is the impugned, Your Lordship. Page 46, Annexure 8. We were already given the power and functions to sit as the executive members, Your Lordship. This is the afterthought of what has happened in the title suit, Your Lordship.
Where is the order of the civil code?
Your Lordship, may I kindly come to page number 32, Annexure 4. The operating paragraph is 42, Your Lordship. Page number 42, paragraph 37, 38, Your Lordship. May I, Your Lordship? May I, Your Lordship?
What is the order passed by this court earlier in the in the abbreviation number 10/21? Who is appearing for the state? What is your stand?
Lordship, on the, we have filed that two affidavits, but from the registrar, respondent number 2, we have not received those. So, as per the affidavit filed, because In fact, a letter for renewal came and as a STO, then we received we forwarded the same to the Deputy Commissioner, who in turn forwarded the same to the this registrar. Respondent number 3, affidavit filed by respondent number 3.
Under
Page-
which provisions of law
Page 6.
a reed court can entertain a petition for execution of an injunction order passed by a civil court?
Lordship, I am not against the injunction order that has to be entertained by this honorable court. My only humble prayer, Your Lordship, in this writ petition is that the impugned the renewable certificate which was obtained by the respondents for setting aside of that.
The matter is pending before the civil court.
Yes, Your Lordship.
How the reed court will entertain that matter?
Your Lordship, the entire process after that, Your Lordship, after the title suit was instituted, sir, the administrative orders, Your Lordship.
You have obtained an injunction,
Yes, Your Lordship.
right?
Yes, Your Lordship.
The dispute is pending before the civil court.
Rightly, Your Lordship.
Now, in that circumstances, the High Court, in exercising the power of reed jurisdiction, can interfere any such issues.
Your Lordship, because Your Lordship, the impugned renewable certificate, Your Lordship, it was issued by the.
If it was wrongly issued,
Yes, Your Lordship.
or without considering because the dispute between the parties are pending before the civil suit.
Rightly, Your Lordship.
That is the reason to whom you should have brought it to the notice.
Pardon, Your Lordship.
To whom you should have brought it to the notice. When the dispute, it is not finally decided.
No, Your Lordship.
Suit is pending.
Yes, Your Lordship.
How the High Court will interfere?
Your Lordship, because by virtue of this renewable certificate, Your Lordship, they are
you
still
should have-
functioning.
That you should have brought it to the notice of the civil court. That in spite of that, you have not made the authority of the society's registration of the Arunachal Pradesh a party respondent in that proceeding, in the suit, as a party. Where is the plaint?
Pardon.
Where is the plaint? And the
Plaint, Your
injunction
Lordship.
petition?
Plaint, Your Lordship, I have not brought to you.
Then, have you made the authorities of the society's registration act as a party respondent in your suit?
No, Your Lordship.
Then how do you bind? If you have not made them a party respondent in the suit,
Lordship.
how will you be able to bind them? See, don't think that reed court is a market. You can buy and purchase anything from the reed court. Wrong fact. In fact, wrongly you have approached this court. And the respondent authorities also could not place the facts before the court. Simply filing affidavit will not do. This kind of affidavit, how will you adjudicate the matter? You have filed a suit against the respondents.
Yes, Your Lordship.
In that particular suit, an injunction order was passed in your favor.
Lordship.
And the authorities under the Society Registration Act, in spite of that injunction order, has given them, certified them, they have authorized them, and a Society Registration Act notification has been issued in their favor.
Lordship.
Right? Now, since the dispute is pending before the civil court, reed court cannot entertain. Number one. Number two, in the suit, you have not made the authorities concerned as a party respondent. That is why you should have annexed the plaint, the injunction petition. Then only the court could have come in to see. Those things are not there.
If Your Lordship may allow me to bring that on record, Your Lordship.
Not necessary. You can simply place it.
Yes, Your Lordship. Then this matter may be kindly fixed on 27th. If possible, I'll bring
Why
that.
on 27?
Because,
Why
Your
not
Lordship,
tomorrow, day after?
Your Lordship, I'll be out of station, Your Lordship, for some medical.
27 will be too long. Before that, you can ask 24, 25, 26, whenever.
26th, then, Your Lordship.
On 26th,
Obliged, Your Lordship.
on the priority council for the petitioner. List on 26th.
Obliged.
Item number 11.
Morning episode. Time is up to 4:45, right? Yes.
Your Lordship, on the last occasion we have,
What is the matter about?
it's about a ejectment
Ejectment from where?
from alleged
Mr. Sharma, any matter pending?
Number 31 is there.
You don't think so you'll be able to do it today?
Fix a date.
Give us a date.
27. The other matter.
Who is in the other side?
Other side, Power Department Council is there.
Okay. In Power Department Council.
Listening permanent.
Army is here, I think so. You are here. Why it is for orders?
We are yet to file affidavit in this case matter. Within the portion.
You have not yet filed.
Issue is pertaining to a contract matter, NIT, wherein ultimately when we were found to be L1, there was one memorandum brought in between, this was a part of the SBD. Based on that, they have justified the rates and made me below L1. My L1 status was converted into a non-L1 status, and someone from the third position was made L1. That is the issue.
When that memorandum was placed, when you bought in, it was not in the bid documents.
That SBD did not indicate that the government will be now applying a memorandum, independent memorandum of justification of rates. So therefore, the bidders were in dark. We never knew that there will be one justification based on some memorandum, which is not even a part of this. And the dates are very interesting. The date of the MOU is 18/9, and the last day of submission of the tender was 21 or 26, something like that, for the same month. So within 2 days, prior to 2 days of that, they brought in a memorandum behind our back, utilized it, and then L1 was now thereafter deprived of the work by saying that your rates are below 17%.
That memorandum was circulated?
No. It was not in the knowledge of the bidders, not circulated, not a part of the SPG, and the S.
Copy of that memorandum. Do you have? Ma'am, just a minute, we'll come back to you. Let's see, 30. It's a part of the annexure?
Yes, also annexure, yes.
Which page?
Page number 181. This is dated 18 September 2023. This was like changing the rules of the game after the game has begun. It doesn't form a part of the SBD.
Where is that?
SBD? Yes. You will also see page 31. First of all, page 31 is the NIT. Page 31 is the NIT. Lordship will see it below that chart. The chart, if your Lordship will see, the last date of receipt of uploaded complete documents date. Lordship will see the date vertically, 12/9/2023. This was by way of a corrigendum. It was changed to 21/9/2023. By an additional affidavit, I have brought that corrigendum also on record. And in the meantime, they have given this corrigendum to extend the date because they wanted to.
What is the corrigendum?
Yes, corrigendum is in the additional affidavit. I filed additional affidavit on 25/2024. Therein, at page 12.
Office order.
Office order. Lordship will see the last date of bid document received and opening is postponed to 21 September. And by the next corrigendum, though the bid submission remained 21, opening was again extended to 26. Normally, bid submission date and opening happens on the same day. Bid submission remained 21. Opening was again extended to 26. So effectively, 21 was the date when the bid submission, last date was there. We submitted accordingly in between. And 2 days prior to that, they have incorporated or they have formulated this memorandum, which was later on used in this NIT process to non-suit me without there being any intimation to that regard. Now, if your Lordship will see the SBD.
And that's okay. Fine.
The SBD says if you want to incorporate anything, it has to be by way of an addendum. That is clause 7, page 66. Addendum, amendment. That has not been done.
Yes, Mr. Parme, when you file your affidavit.
Well,
there is no stay in force.
No stay, my lord.
But it was supposed to be considered on the next date.
My lord, in this case, my lord, what when, my lord?
And the financial bid statement is at page 174. Lordship will see that I was the L1. Page 174.
My lord, in this case, my lord, now authority, my lord, have considered
Joint
committee, my lord.
account 25 crores, 75 lakhs.
May I, my lord?
They have non-suited me by saying that the
No. When you file your affidavit.
My lord, due to this, my lord will see this, my lord. Now, all the grievance, my lord, raised by the petitioner, my lord, is also under consideration, my lord, by this, my lord, this order, my lord. Now, we are, the approving authority, my lord, is looking into whole aspect, my lord, whether his reaction or reaction, my lord, is wrong, my lord, or right, my lord. That whole aspect, my lord, including his financial bid, my lord, is under consideration, my lord. That's why, my lord, we are.
Give it to the court. If that is a fact that they are reconsidering, then till then there should not be a.
Is it there?
Please.
My lord.
It is not there. Where are you saying from reconsideration?
My lord,
Finally,
term of reference of the committee, my lord. One, my lord, re-examination process, my lord. The committee shall examine whether the price quoted in the bid identified as abnormally low. Now, on this ground, his bid was rejected, my lord. Require a justification to be sought from the relevant bidder. The committee shall examine the justification provided by the bidder from their bids. This review shall include an analysis of the bid with respect to subject matter, scope, delivery scope. All this, my lord. This is other active consideration, my lord.
So till then they should not proceed with giving LOA to the.
None, my lord. That's why, my lord. I have placed.
Undertaking is given.
I have placed on
some
record.
aspect I will be protected as of now.
I place on
now
record.
the 15 days period is already over. What action you have taken?
My lord, after I am informed, my lord, 2 sitting, my lord, has been done in terms of this order, my lord, 2 sitting, my lord, by the committee, my lord. Not finalized, my lord. Now, At this stage, my humble submission, my lord, there is no question of passing any interim order, my lord. As the authority, my lord, is looking into the whole, my lord, issue, my lord, including the petitioner, my lord. No,
So there can be an order from the court that since the Department of Power have issued this memorandum on 22nd of March 2024, in which the case of the petitioner is also under consideration,
but that give consideration.
right?
Yes, my lord.
As on date,
My lord.
no such speaking order has been passed by the said board,
My lord, no, sir.
right?
Right. No, sir, no, my lord. Not yet, my lord, not passed.
That's it, and that only after passing of the speaking order, the tender will be given to the
My lord,
concerned party.
My lord. Then-
In
That
way of-
protection may be given to me.
Then let go. You are also consideration, then this entire petition goes.
Other
This,
issue, my lord, my
this
humble
is something
submission,
that they have done during the session of this matter. Now, if
Definitely your client will know.
Yes,
Yes.
Matter is of March, not
Yes.
of June.
No, but till now, there has been no consideration that has been communicated to us in this aspect. So suddenly tomorrow, if an LOA is given to the other side,
my lord, I am placing a record before this on my report, my lord. This is, my lord, unnecessary impression, my lord.
So you are relying on this.
Yes, my lord, truly, my lord. That's why I placing this on report, my lord.
Okay, we'll pass the order tomorrow.
yes, Lord.
Mr. Parme, if you have any other information, just let us know tomorrow.
There should not
We'll
be
pass
any
the-
issue of res judicata later on because
Definitely
this
not.
is the issue.
Definitely not. We'll pass
Because
the
tomorrow they will
report.
say, I already filed a petition.
Places. During the deliberation of the matter, Mr. Parme, counsel appearing for the Department of Power, Arunachal Pradesh, placed the memorandum dated 22/03/2024. List tomorrow. Enabling Mr. Parme, standing counsel, Department of Power, to place the relevant instructions in the matter.
Yes, Lord.
And for consideration of this petition.
But yes, Lord. Obliged, Lord.
Obliged.
Yes, ma'am, where are you? Yes. Will not take much time of you. Just tell us, what is your meaning? You have been ejected,
Yes, it's,
already ejected,
yes,
or there is any stay order in your force, in your favor?
Your Lordship.
Whether the ejectment order has been executed,
No, till now not, because there is interim.
there is an interim.
Yes, Your Lordship.
What is the stand of the government? Stand of the government, authorities, forest officer.
Lordship, it's a forest reserve land.
Forest reserve land.
No, sir.
Fine.
Already notified in 1941, Lordship.
Now, how you have verified that this is a forest land in occupation of the
Lordship,
petitioners?
we have filed our affidavit, Lordship.
Any
From
reason
the
to
record,
that?
Lordship.
Okay, let us do it on Monday. We'll take it up on Monday.
Yes, Your Lordship.
What's your good name?
Sonam.
Heard such and such for the petitioner and Mr. such and such for the respondents in the forest department. List on 24 for further consideration.
Interim may be continued, Lord. Interim may be continued.
It is there. I think so it is until further order. But in the last order, 28th of May 2024, there is no order has not been extended.
It is in 16/07/2023. It was first given on 1st of March.
True, but last order was of 20/03/2024.
Maybe,
On 28th of March, last order was extended.
maybe Your Lordship it missed, but it was
But on 20, thereafter,
28.
on 28th of May 2024, the interim order has not been extended. See, this is the order. It was extended till the next date of listing. So thereafter, the matter came up on 28th of May. And 28th of May, there is no stay order.
Maybe we missed.
How do you, without any application, how will you pass that order? Without any application, court cannot pass ante order.
No.
Yes.
So you have to file appropriate application for continuation of the stay order. Probably you have not mentioned before the court. Should have mentioned it before the court. Petitioner was directed to take first steps. What happened? You took?
Yes, Your Lordship, but we just got the track number from the registry, but it's not working, so we will check it, the tracking number.
Okay, then Monday. Any other matters?
Item number 12. Lordship, we have received the instructions and we will be filing the affidavit shortly. Two weeks time maybe granted.
Office note dated 17/6/2024 reflects that the petitioners are yet to take on the respondent numbers 6 to 9 as directed by the court earlier on 21/05/2024. Time granted to the petitioners up to by order date 21/05/2024 to court granted only 2 days time to the petitioners to take steps on the respondent numbers 6 to 9. Petitioners are allowed to take steps on the respondent numbers 6 to 9 as directed earlier on 21/05/2024 on or before 21/06/2024, failing which the claim of the petitioners against the respondent number 6 to 9 shall stand automatically deleted.
My lord, here in this case, I was representing respondent number 5. So I'm for respondent number 5. I would like to inform that we are no longer participating in the case. Therefore, I pray to strike out our name.
What's your good name?
I'm appearing on behalf of conducting counsel, Mr. Rajesh Sunar.
That will not do. Our Sunar has to be here. You're a junior counsel, you will be trapped. We do not want such kind of things. On the concerned counsel who has filed the Okalatnama shall have to be here.
My lord, right now he's standing on his leg is at court number 2.
Doesn't matter. On the next date you do. Okay. List on 26th. Yes. No representation on behalf of the petition party is on call.
May I please, Lordship? Lordship, I am here, my lord.
Oh, you are there.
Yes, my lord.
Correspondence, Mr. Kato is not here.
Date may be fixed, my lord.
Tell us when.
After vacation, my lord, on 25 July, my lord.
25th of July.
Yes, my lord.
On the prayer of the council for the petitioner, Mr. H.L. Oscar. List this matter. For hearing on 25/07/2024. Okay.
Most obliged, my lord.
Just on the said date, the respondents who was the disciplinary authority? Who was the disciplinary authority?
Lordship, ITPP department, my lord, force.
The respondents in the ITPP department shall place the relevant records in original regarding the disciplinary proceeding initiated against the petitioner as per the direction of the court dated 27/05/2024. Okay. That will do.
Most obliged, my lord.
Okay. It will, video or video. It will